March. Hang on, okay. Difficulty, sorry. Everyone great? You're good. All right, today is Wednesday, March 18th. At this time, I need each audience member to please stand and state your name clearly for our court reporter. And we'll start with you, sir.
Michael Garber, Board of Wilderness Program. Scott Daniel, Board of Pharmacy.
Anne Marie Nolan, Board of Pharmacy.
Jim Driscoll, Driscoll CPA firm. Public Gray, the Southern Group.
Bianca Versis. Kennedy Schumacher, Sanford University.
Jennifer Campbell, Mass Plus Consulting.
Melissa Farrow, Walgreens. Berkeley Sykes, Huntsville Hospital. Sorry, no, you go right ahead.
Carrie Moon, Tuscaloosa VA.
Brianna Watkins, Tuscaloosa VA.
Brianna Alex, Tuscaloosa VA.
Allison Souders, ABCI.
Hey, Garrett Akins, Tuscaloosa VA.
Louise Jones, Alabama Pharmacy Association.
Crystal Anderson, Board of Pharmacy.
Wendy Passmore, Board of Pharmacy.
All right, thank you, everybody. If you are on WebEx and you don't have your full name listed on the screen, please email your full name to John Lena at jdlena@albach.com so that we can put you on the record as attending. And at this time, I'm going to ask Mr. Brooklier to lead us in a prayer.
You would please bow your heads. Thank you, most gracious and heavenly Father. Thank you for all that we have. Help us to always be mindful and grateful of that. Thank you for this great country we live in, this great state that we live in. Guide us today in what we do. Help us to have good insight as to what we're proposing. Help us to listen to those who have other arguments and disagreements and comments. Help us to understand and help us to all find common ground. We ask these things in the name of the Father, Son, and Holy Spirit. Amen.
Amen.
All right, we'll stand and do the pledge. I pledge allegiance
to the flag of the United States of America and to the republic which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Secretary, would you please call the roll?
Yes, Mr. President. Dr. Mitchell. Here. Judge Stokes.
Here.
Ms. Booker.
Here.
Dr. Penner. Here. Dr. Marbury.
Here.
Dr. Hicks. Here. Ms. Giles.
Here.
Mr. Brooklier.
Here.
And Dr. Cobb.
Here.
Mr. President, all members are present and we have a quorum.
Thank you. Do I hear a motion to adopt today's agenda?
So moved.
Is there a
Second.
motion in a second? How do we vote?
Aye.
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 And I vote yes. All right, we'll proceed on. We need to approve last month's minutes of the first order of business. So if you would take a look at your February 2026 business meeting minutes first. Okay. All right, do I hear a motion to accept the February 2026 business meeting minutes?
So moved.
Second.
I got a motion and a second. How do we vote?
Aye.
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 Stay.
Aye.
And I vote yes. Minutes are approved. If everybody would take a look at the February 2026 interview minutes. All right, any comments? All right, can I get a motion to approve the February 2026 interview minutes?
So moved.
Second.
All right, got a motion and a second. How do we vote?
Aye.
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 And I vote yes. All right, we've got our next item on the agenda is presentations from Aspen Pharmacy. But before we do that, I do want to welcome our two new board members, so we're finally at our full 9. Judge Freddie Stokes has joined us, and we had a good day yesterday. And Dr. Nathan Penner has joined us as well, and we had trial by fire a little bit yesterday and again today, if you will. But we welcome them and are excited to have them, and have had good interactions so far and look forward to working with them. Yes, sir.
Mr. President, we snuck in on the agenda for the wellness report first before Aspen today.
Okay.
If we could do that so that Dr. Garver can get to his next appointment.
Yeah, absolutely, absolutely. So we'll go out of order real quick and go ahead and take our wellness report.
Thank you, and I want to thank staff for arranging this for me. I've got to go to George's to reconsider and meet with one of our licensees there this morning. And it's good to be here. I'm using an Air Super inhaler right now, which has ruined my voice, and I hope that'll turn around pretty soon. I want to thank the new board members here and welcome you. And you've picked up a fairly thankless job, but very necessary one in helping our licensees. My name is Michael Garver, and I'm the director of the board's wellness program, and I have been for the last 15 years. I work with other boards as well, and my main job is helping the board to identify health professionals, that licensees who have problems with substance abuse or alcohol abuse or addiction or mental defects and mental problems, and to get those people evaluations, the necessary treatment if they need it, and provide any kind of monitoring that the board sees fit to do in order to bring them back and have them stand before the board in a manner which the board can feel like they can practice with reasonable skill and safety and relicense those individuals. So that's my job. And today, I would say, since you are new, I do this 24 hours a day, 7 days a week, just about. And I'm open to any questions you have about anything that you do, any loved one, any family members that reach out to you or friends. If there's anybody that I can help you with, if there are any questions about how this program works, you can text me or email me. My number's on all the stuff around here. And we can talk and chat about it, and I'd be glad to do that. But I am here today to read into the minutes the active work of the Wellness Committee at this time. And it's a new statistical report because it's been burdened on me by other health professionals in the pharmacy world, along with some friends that I trust, that too much personal information has been given out that might cause a problem with staff who process that information, and also with the individual being identified in some kind of strange way, but by what I've said up here. So I'm going to give you the statistical version of this. You do have the old version, I think, in your stuff today. And I had even cleaned it up from what I did for the last 15 years. I have already met with the other boards I represent this month, and given that this type of report, and it's been accepted. However, Mr. President, if the board feels like that I need to add more to this report at any time, this is a report for you, and you simply need to let me know, and I'll be glad to change that. So this is the current work of the Wellness Committee and the Wellness Program right now. We have 7 pharmacists in process at this time. That is, that they may be in residential or outpatient treatment, being held out by order of the treatment center or order of the board, or they are presently in or going for an evaluation. There are 2 pharmacy techs in process at this time under those same comments. There are also 2 pharmacy techs in process at this time that I have not talked to or who not returned my phone calls and emails for any particular reason. There is 1 pharmacy student in process at this time who may be in residential treatment or being held out or going for an evaluation. And we have 2 pharmacists who have recently completed their order, outlived their order with the board and completed their contract with the Wellness Committee and are now licensed and are fully active. And when I say these people are fully active, the board strives to bring all of these people back into the full active practice of pharmacy. And that is, some of them have probation, some of them do not. But all of them, if they do whatever they're supposed to do, this board 100% of the time has voted for those people to be returned to the active practice of pharmacy. Outside of this number, we have 43 pharmacy health professionals who are being monitored at this time. And as a note, which I left off when I was doing this, we collate and are the keepers of 671 digital charts that comprise the whole of the amount of individuals who have been treated and or contacted and helped by this board. So that's all I have for today. If there are any questions for me, anyone has.
Questions for Mr. Wall?
Thank you so much. Glad to see all of you.
Yes, thank you, Dr. Garber.
Thank you, Dr. Garber.
All right, we'll move back up in the agenda to presentations from Aspen Pharmacy. Who is representing Aspen today? All right. You come to the podium. Sherry, you gonna swear her in?
Will you raise your right hand, please, to be sworn? Do you solemnly swear or affirm that the statements you are about to make will be the truth, the whole truth, and nothing but the truth? Thank you.
Hey everyone, my name is Bianca Bracis. I am the pharmacist in charge at Aspen Pharmacies. So I just have a brief presentation on who we are and why we're seeking licensure. So we're Aspen Pharmacies. We are located in Livingston, New Jersey. We are a non-dispensing hub services pharmacy. So we do not stock, store, or fulfill any medications. We partner with pharma manufacturers and specialty pharmacies. We have a wide network of specialty pharmacies that we partner with to support patient access to specialty medications. So like I said earlier, we do not dispense any medications. Prescriptions are ultimately fulfilled by unaffiliated licensed dispensing pharmacies. So what we pretty much do is we intake a prescription, do order processing. We'll do any ARCS clarification if needed, benefits investigation, copay support. A lot of the medications that we support are specialty or limited distribution, so they're not able to be filled anywhere. So our goal is to help patient access and then ultimately transfer the prescription to a pharmacy that is contracted with the patient's insurance and able to fulfill the order. So our goal is to streamline patient access to specialty meds, and we support coordination between patients, prescribers, payers, and dispensing pharmacies. I think I have one more slide.
You get a clicker over there.
Yeah, the clickers, there was shit, he got.
Gotcha.
There we go.
So just a little bit about why we're seeking licensure. So Aspen Pharmacies is seeking a pharmacy services permit as a part of our effort to obtain license in all 50 states. So gaining licensure actually provides us the opportunity to expand our pharmacy services. Right now, clinician counseling and care calls, fall on our partner pharmacies, the one who are actually filling the medications. But this would allow a more streamlined patient experience. We would be able to counsel patients, do adherence calls, care plans, et cetera. Any questions?
Any questions?
So this is the thought that with the pharmacy services permit that, the clinical monitoring, the counseling, the therapeutic duplication, everything that a pharmacist does would be done centrally by you guys. And then y'all would just notify the pharmacy in Alabama, it's okay to ship drugs to this patient.
Right. So it would be a singular patient experience. So we would be able to do the counseling and whatnot. So the patient only really knows who we are. They don't necessarily but before we do any transfer, we make sure that the pharmacy is able to fill and we get patient consent. Before we do a transfer, they ultimately have the final say, on where the medication is transferred. But in this case, it would be more of a singular patient experience. So, any concerns, anything at all, they would reach out to us.
So your pharmacy, New Jersey would again handle all the insurance investigation, the counseling, communication with the physician, and then a contracted pharmacy or a pharmacy in your network in Alabama would just get a notification to dispense.
Big package it, yep. Mhm.
And so that pharmacy in Alabama, would they have medication profiles on that patient to know what other medications they were dispensing? Or I'm sorry, what other medications they were receiving?
Yeah. So we have a vast network of partner pharmacies. I mean, there's hundreds across the country. So it depends on their model. Some of them are like API integrated with our system. So they have the same access to the system so they can see all the notes we leave, et cetera. Some of our partners, we collect copay on their behalf, through like a token and then charge a patient credit card that way. So it just depends. We do transfer out of network, not a partner pharmacy, so we'll just do, a traditional fax or verbal transfer to any other pharmacy. So it really just depends on our, relationship with that pharmacy.
So you'd be counting on the local pharmacy in Alabama knowing the rules and regulations of the Alabama Board of Pharmacy to know what documentation they have to have prior to dispensing it.
Right. So if a patient is in Alabama, we have blocks in place that, the patient's insurance or that prescription wouldn't even round robin to go to one of those pharmacies if they're not licensed to dispense to a patient in Alabama.
Any further questions? So I've got one. How do patients access you and how do you get the prescription to begin with?
Yeah. So most of our prescriptions come directly to us from the prescriber, or we get transfer ins from other pharmacies. How providers hear about us are mainly through manufacturer sales reps. So a lot of these medications are limited distribution. So the manufacturer they send their sales reps out, they tell them about us, and they send prescriptions to us to help, patients gain access to these medications.
So you're not filling the prescription at all. So I guess where's the revenue model in that? I'm just curious.
So yeah, we don't bill insurance. We're paid directly by the manufacturers.
Okay.
Yeah.
So you basically are doing benefits and
Yes.
investigations on behalf of the manufacturer.
Right. Mhm.
Sorry. I know several of these, you talk about shipping and things like that, I guess. Do you have any safeguards for, I guess those pharmacies are responsible for shipping the drugs to the patients, but you talked to the patients, just communicate with you guys, like, if there's issues there, what are y'all's kind of protocols
So
there?
we work together. So like in the patient profile, if there's any shipping errors or.
If it shows up, it's not cold or,
Yeah.
especially fast.
So, if there's an error like that, it ultimately falls with the fulfilling pharmacy, to do any sort of replacement, or if there was a shipping error on their end. What we will collect copay and we, collect the patient address. But if there's any sort of shipping error where they're concerned about the package condition, or, if it's a cold chain ship and it will fall on the fulfilling pharmacy.
If things go well, they just communicate with you and everything's great, but if there's issues, then they have to communicate with the.
They usually come, to us, and then we could direct them to the fulfilling pharmacy. But, when they get their prescription, the label, everything is from the fulfilling pharmacy.
You wouldn't
not
negotiate
us
on
as-
their behalf or anything.
What was that?
You wouldn't negotiate on their behalf if they were continually having problems with the pharmacy, you're not gonna intervene or anything like that,
I
or.
mean, if there's a pharmacy that has continual issues, then we wouldn't partner with them, yeah.
All right. Any further questions? Board member? Okay. Do I hear a motion to approve?
President, I
Yes.
think are we still waiting on their policy and procedure manual submission? So as part of the application process, we just need to see that part of it. I think we're satisfied with the business model, but to make it complete.
We can approve contingent upon. Okay. So, do I hear a motion to approve Aspen Pharmacy in New Jersey for a pharmacy services permit contingent upon satisfactory submission and review of the policy and procedure manual.
So moved.
Take a second. Second. Got a motion and a second. How do we vote?
Aye.
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 And I vote yes. So if you'll get that policy and procedure manual to them, then we can finish processing. All right, thank you. The next item on the agenda is our treasurer's report. Mr. Treasurer?
Got to find it. Okay, some points about the fiscal year and this year. We're 5 months in. So total revenues for the fiscal year are at 70.9% of annual budget. But remember also that our revenue is typically more towards the beginning of the year. Operating expenses for fiscal year is 39.19% of annual budget. A few specifics on the sub-accounts that need to be, everyone needs to be made aware of. The licensing fees revenues are 73.55% of the budget projection. Building, equipment, and grounds are at 83.54% of budget. This line will remain outside the budget norms for the remainder of the year due to elevator service contracts, irrigation system repair, and fire alarm repair costs. So that's something that in budget talks for the next year, we need to take into account because going through procurement's costing us more money. And so we're gonna have to somehow budget that. And that's all I've got.
Thank you, Mr. Treasurer. Do I hear a motion to accept the treasurer's report?
So moved.
Second. Got a motion and a second. How do we vote?
Aye.
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 Stay.
Aye.
And I vote yes. Thank you. All right, Chief Investigator's report.
Thank you, Mr. President, members of the board. The Chief Investigator's report, February, has been uploaded to Dropbox for your review. This report contains comprehensive statistics related to inspections, investigative activity conducted during the month. During the month of February, investigators completed 161 compliant inspections. Just as a note, of the 161 inspections, there were 0 issues observed that would rise to the level of generating a complaint or statement of charges stemming from the inspections. During that same period, the board received 24 complaints and completed 31 investigations. Year to date, a total of 48 complaints have been received. Of those complaints, 3 have been referred to legal counsel for further review regarding potential Pharmacy Practice Act violations that may result in the issuance of a statement of charges. Since the last board meeting, 1 pharmacy burglary has been reported. The burglary occurred in the Northern District of Alabama. While the burglary numbers for this month were minimal, ALBOP continues to encourage all licensees to maintain situational awareness and promptly report any break-ins, suspicious activity, or criminal incidents to the Alabama Board of Pharmacy. During the month of February, ALBOP received reports from licensees regarding fraudulent telephone calls from individuals falsely identifying themselves as ALBOP investigators or agents affiliated with federal agencies. These callers may be highly convincing and may provide licensees personnel, professional information such as work addresses, home addresses, cell phone numbers, NPI numbers, and Alabama license numbers in an attempt to appear credible and establish a sense of authority. In some instances, the callers attempt to pressure individuals into providing money or taking immediate action to avoid alleged enforcement consequences. As a note, ALBOP will not contact licensees by telephone to collect fines, fees, or other types of payment. Alabama will continue to provide these notices so that all licensees are aware these impersonation attempts are occurring. Licensees are encouraged to remain vigilant and exercise caution when receiving unsolicited calls from individuals claiming to represent regulatory or law enforcement authorities.
Thank you. Is there any questions for Chief Investigator Shaw?
Good question. Like from my notes, y'all did 149 inspections for January. Returned 0 for follow-up or fractions, and then 161. So it's 310 inspections this year with none returned. Can you add that to your monthly report that you do a running total of for the year, how many inspections compared to how many the investigators sent for issue?
Yes, sir.
Thank you.
I do have one question, Ms. Shaw. Where are we with these vehicles?
They are in the process of being purchased through, we've been in communication with the Stivers. We're ordering Durangos, Dodge Durangos. We just had to be back and forth with them on getting the quotes in, and then has to go through the procurement
Do
process.
we have an expected delivery date?
Sir,
Do we have an expected delivery date?
not a delivery date. No, sir, not at this time.
All right, thank you. I just know that that's a major expense and on our radar, and I think we all want to know that.
I will continue, I will update you, on the, as it moves along.
Thank you. All right, the next item on our agenda is our Executive Secretary's report.
Thank you, Mr. President, and members of the board, now including our two new and final members for 2026, Dr. Nathan Pinner and Judge Freddie Stokes, who have joined us this month. Since our last meeting, there have been no reported pharmacy closures statewide. I've been contacted by Department of Public Health's PDMP division. They're experiencing some key challenges with the program and asked me to share some information. First and foremost, pharmacies can expect to receive their error correction requests rather from Vicki Walker at ADPH. She's the PDMP Pharmacy Compliance Administrator, and pharmacists should respond to these emails for correction. The most common error submissions that PDMP sees are missing or invalid prescriber DEA number, a missing patient address, and missing NDC and quantity of controlled substances and compounds. As a reminder, all pharmacists can create a PDMP account by visiting alabama.pmpaware.net. Your pharmacy management systems can incorporate PDMP as an in-process check. There may be a one-time setup fee required by the pharmacy, but ADPH covers the monthly fee for that access. ADPH has announced a slightly different plan for their substance misuse summits for 2026. They were held in Montgomery previously. That'll be done as 2 summits, one in Mobile on August 18th and one in Huntsville on August 20th. Details can be found under both the pharmacy and PDMP pages of the ADPH website. And I have links here that are meaningless to you without having the document that's in Dropbox. Also this week, the Department of Insurance has launched a number of changes to their website, aldoi.gov. Key changes including an updated fax number for that agency or for that division, updated complaint forms, both consumer and pharmacy, a pharmacy complaint best practice document, which everyone should take a look at. There's some common tips and tricks about things to include and not to include. I've heard Dr. Newman referred to people including the provider tax in their assessment. It's not a part of the over and underpayment calculation. To support that, there's also a reimbursement complaint template on that site. And a link here for that as well, which again is not helpful without the physical document. As board members can also report, we see a number of technician applicants on a monthly basis who run into challenges getting an initial registration. One of the most common issues we see is a tech candidate answering no to the question, "Have you ever been arrested?" Board will run a comprehensive background check, and failure to disclose an arrest will result in a required appearance before the board before registration is considered. It's a common misconception that pretrial diversion and plea deals are not on the record. An arrest is not an automatic disqualification from registration, but a failure to disclose is making a false statement to the board, makes the appearance more challenging for the tech candidate. Any pharmacies who assist their tech candidates with the application process are encouraged to carefully consider whether they're allowing their candidates to privately and accurately answer the application questions. Alabama Pharmacy Association has hosted 2 events since our last meeting. Ms. Giles, Dr. Hicks, and I were able to attend the midwinter meeting where we presented an update on board composition, recent rules, rules in rulemaking, and bills of interest, in addition to holding a stakeholder listening session. There was also a legislative session at that meeting. I think they did a good job of pulling in our state legislators to engage with stakeholders there. They also had the APA legislative reception in Montgomery, which is a good opportunity to connect with the team at APA, state legislators who attended, and then our own pharmacy stakeholders at that event. We also have some upcoming events with ALSHP and look forward to the opportunity to connect with stakeholders on the institutional side. Board staff have received reports in the past month from a few pharmacists about email solicitations and online job postings for inspection and credentialing only. This recruiter advertises a position for a one-time commitment to attend the ALBOP inspection and a provision for an active AL pharmacist license for credentialing applications. Pharmacists should be apprehensive about this in similar situations. A pharmacy using a professional's credentials exposes the credential holder to liability for the actions of the operation, and there is no provision for credentials used as placeholder for compliance purposes. Pharmacists should also remain aware that there are pop-up scam pharmacies that hire local pharmacists, bill thousands of prescriptions to third parties, and disappear overnight without ever having received inventory. Thank you to Dr. Tyndall, Dr. Anderson, Mr. Daniel for their extra time spent this month on the MPJE item development. That process is done for this year. I have a number of updates on bills. In the interest of time, I'm not going to read that, but that is available in the version in Dropbox. And finally, we do have an update this month on hearing room furniture that we've been chasing for a number of months. The quote is in Dropbox in the Executive Secretary folder. They're from Ingram State Technical College Vocational Education and Job Training Program for Incarcerated Individuals to handle the furniture, and Stone & Sons for electrical work on the same project. Combined estimate on those comes to just over $7,900 compared to the furniture only quote that we've seen before that was $15,000 up to $50,000 or so for a full carpentry build out in the past. With the board's approval of those proposals, we can move that forward with a turnaround time of roughly 50 days on the furniture plus time to move. We would have a small additional expense for truck rental and a moving company to get it upstairs.
Fabulous, fabulous.
We looked around long enough.
Yeah.
We've been fine.
It's been a journey.
Do we need to make a motion to approve that and to get that going?
Yeah, I think if you review the proposal and
Oh, I looked at it. Amazing.
Yeah, it's in your Dropbox if you haven't looked at it. Take a second. And
I looked at it and I determined that I can't build it much cheaper, so.
I have confidence in you.
You know, I mean, I was planning on bringing out the plywood and doing it myself, but here we are.
It may not be perfectly clear from the drawings, although there is a drawing there. It will be built with matching trim profiles. He's going to come out and do a stain test to match as closely as possible. It would be two 8-foot cabinetry sections that can be moved. There'll be plug mold installed on it that will plug into floor outlets, so that will core drill the floor and tie into an existing circuit, so that we can unplug them and move them out of the way if we need to do something different with the space temporarily. We'll have that option. We'll have a transaction counter so that there'll be a way to keep things from rolling off the back. The top counter is gonna be wood and not marble. We can decide to upgrade that later if people decide to do that, but the whole thing will be built and stained to match the existing cabinetry.
Is it movable or no?
It will be
It would
movable.
be movable. Any questions? Any questions? We want to approve that today?
I think
I think
so.
so.
Can I hear a motion?
So moved.
I second.
I got a motion and a second to approve the bid for our additional tables for our new board members. How do we vote?
Aye.
Aye.
And I vote yes. So, Mr. Secretary Lana, if you could go ahead and get that underway, I know we'll all be looking forward to finally putting that issue aside.
We'll get it moving, and that's all I have for this month.
Thank you. All right, now we'll move into old business. The first item in old business is an update on 680-X-2.34 and 680-X-2.35.
Should
Um,
be attorney's report first.
Oh, sorry. Just skipped you.
That's okay. If we want to do it next month, we can do it next month. But
Go ahead.
I have a little bit of information I'd like to share with you guys. Thank you, Mr. President. Good morning, board members, especially to our newest members, especially welcome you. Dr. Nolan has a slide deck from me. It's just short. I just wanted to share with you guys and with the public, frankly, some information about things that we have been working on as legal and staff, especially relating to contested cases in due process. Of course, we all understand and agree that with Sunset, our last couple of reviews, and with just recent events here at the board, I mean, a lot of the concerns that we have arise out of contested cases. Are we really providing due process to licensees who were involved in disciplinary procedures? So that is something that I think when you guys hired me, you wanted me to really take a hard look at and address and make sure that we're doing well. And so that's something that we are working on. We want to share with you a couple of things that we're developing and will be deploying soon. So if you can click on to the next, Dr. Nolan. And this will go sort of sequentially. I only really have 3 slides. So starting with just the investigation and pre-hearing, we sometimes receive surrenders during the investigative process. A couple of things that we were working on. We did not have a formal written notice of investigation that we gave to license holders, or permit holders, when they're under investigation. Why is this important? There's at least 3 reasons. People should know, right? If we are looking into something that they are doing, people have a right to know that. So just providing simple notice that, hey, just so you know, we have an open investigation on something going on, that's important for us to do. Secondly, sometimes you do have licensees who do not renew while they're under investigation, and that is reportable to the National Practitioner Data Bank. So part of what that document does is just informs them. If you do not renew your license when it comes up for renewal, and this investigation is still outstanding, you will have an NPDB report. It's not up to us, it's federal law, but it's just fair notice. Renew your license, okay? The third reason for that really is we want people to know so that they don't either intentionally or inadvertently destroy evidence that may be relevant to the investigation. If we ask for a bundle of documents and a respondent says, oh, well, those rolled off of retention, that really should not happen. If we have an investigation going, respondents need to preserve, or at least not affirmatively destroy, evidence that had confusion, frankly, in terms of some of our forms that we had been using. When it comes to the nomenclature of what is a voluntary surrender, this was really confusing to me when I came in. There's really two different things that happen when someone wants to surrender their license. Only one is really a voluntary surrender. So I've split these into two different documents and changed the name of one to make it more clear we know what's actually happening. There are situations, not every case by any stretch, but there are situations where the issues raised in a complaint and investigation are so serious that we either want the licensee to stop practice while we investigate, or we might even seek an emergency suspension. That's exceedingly rare, but there is a pathway for someone to voluntarily suspend while we investigate and hold a hearing. I'm not gonna call that a surrender, okay? It's a temporary voluntary suspension that allows us to buy some time to do an investigation and have due process if we need it. It doesn't need to happen in every case. It is comparatively rare that those need to happen. It is reportable, but that's addressed in the document. What's really a surrender is if someone wants to permanently surrender their license and forego due process, forego the hearing, forego the appeal, that's a surrender. That terminates the case in almost every case. And so that is a functionally separate and different document that we now have. And I think, Casey, we're going to meet with the investigators to clarify some of these still. So they're not quite done, but we're going to meet with the investigations team to make sure everybody is on the same page to understand exactly what we're doing. All right, so that's it for that page. We've worked on a few new statement of charges and notice of hearings. I want the investigator on the case to review those as a matter of course before they go out. Reason being, and I guess this hasn't been done routinely, but I do want it to happen. We want the investigator who investigated the case to make sure that I'm seeing what I'm supposed to be seeing and that we are charging appropriately with what the facts are in the case. So just an extra set of eyes on that to make sure that we're charging the right thing. Just as a reality check. I have heard from, and I'm not singling anybody out, I've heard from several attorneys, not just one, multiple attorneys who handle cases for respondents in this room. And one thing that I've heard multiple times is they don't feel like they're getting adequate pre-hearing disclosure of the witnesses and exhibits that we're going to present in this room in a hearing. And I agree with what I have heard is not fair. The hearing that you heard yesterday, that respondent received notice of the witnesses and the exhibits that were going to be presented. I'm not going to say quite a month, but it was almost a month before the hearing. And I think as you saw, not only was the hearing fair, but it was smooth because there was no surprises. Everybody knew what was going to happen. That is something that I want to do as a routine thing so that there's full disclosure, there's better due process, there's more transparency. Lastly, on this page, one thing that I'm working on that is a much bigger project is it'd be a whole chapter in the administrative code to codify rules of procedure for this body. When we have hearings and contested cases, anybody who wants to know how things are done here, they will have a roadmap and a rule book that's for me and for them and for the board. This is how we do things. No surprises, right? That is going to be a longer term project because it's a bigger project, but it is something that I am working on. I've just shared I'll let Mr. Lena see it on the screen, okay? It's in an early stage of drafting, but it is something that we're working on. And I hope people will hear and see that we're taking seriously the commitment to due process that we have in this room. All right, next. And I think this is lastly, again, hearing from attorneys who handle cases for respondents in this room, plural, not just one. The way that we have settled cases has been sort of unclear to me how we are doing it procedurally. I want us to have a clear process that is transparent and is fair to everyone, how we propose settlements to the board. Settlements obviously have to be approved by the board to enter it into a consent order. But it also has to recognize that you guys have to stay independent decision makers if it needs to go to a hearing. And so we need to balance those two things. So what I would like to do, and I understand we settled a case in December that went, if not just like this, I mean 99% like this. And this is the way I would like us to do it. Essentially, the executive secretary and I will have, I think we have some sense from y'all as to where you tend to go on cases, and we'll have that in mind as we negotiate with respondents. But it would be the job of executive secretary, myself, to negotiate a proposed resolution with the respondent and their attorney. And once we agree sort of at the staff and respondent level, we would put that into a joint motion and proposed order for you guys. And we would bring it to you in a public meeting. There would be no back channel, to use a term of art, a legal term of art, no back channel communication between me and y'all, or between the executive secretary and y'all about it. It would all happen in a public meeting where we would come in with the respondent and say, here's what we think would be a fair resolution in this case. You could ask questions. I think the board should stay away from trying to renegotiate. If you want to reject it, just reject it. If you want to accept it, just accept it. But it would all be transparent and would keep you guys it would keep your independence intact if you need to hear the case. So, and then you would just sign it. I mean, I would have already signed it, respondent would have already signed it, and you just need one more signature from the board president after a motion, second, and vote to just approve it. And that would end the case. That's something I would like to happen the month before a case is set for a hearing, so that if we do need to go to a hearing, we have time to prepare. We're not coming in on the morning of trial, hey, hold on, everybody, we have a proposed resolution. And we've had to do all the trial preparation and everything, which may or may not be needed. So I want to do it the month before an actual hearing is set. Is that it for all right, were there any questions on anything that we just rushed through? Right. I want to try to give you guys information in the attorney's reports about what we're working on between board meetings and outside of board meetings. There's a lot going on in the building that doesn't necessarily make y'all's agenda. And we want to make sure you guys know that we're taking this work very seriously and let the public know too.
Thank you.
Yes.
Any questions for our attorney?
Very quick suggestion that I think would be helpful for me, especially after the trial by fire yesterday.
Yes, sir.
If, as you begin to think about the consent resolutions, also building some type of data or collection on, very similar to the way it was proposed in the CRCs for us yesterday, of, the facts in that case, no names, and what led to that resolution or consent resolution between the parties.
Sure.
I think that that'd be helpful moving forward.
Sort of like building a library of precedent.
Absolutely.
Sure, that makes sense.
Absolutely. I'm sure it'll make it easier for you 18, 20 months down the road.
Right.
Yeah.
Any additional questions or comments? Okay. All right. Now we'll move into old business. But before we do, we had two people that came in. Can you please stand and state your name for the court reporter?
Jim Easter, Baptist Health.
Joseph Krebs, Law Firm.
All right, thank y'all. All right, so the first item in old business is an update on 680-X-2.34 and 680-X-2.35. And I'm going to defer to counsel for this discussion.
Thank you, Mr. President. Just very briefly, we were looking at, so X2.34 and X2.35, these are rules that you guys approved for certification last month to make increases in the licensing renewal fees for pharmacies and pharmacists. And we want to bring those back to you because in looking back over some of the comments and the rulemaking file on this, we think that we probably should have done a business impact analysis to go along with these. That is something that it's a fairly simple analysis that's set forth in the statute that we are to do. If a business tells us in their comments that they would be adversely affected by the rule, it's something that goes to the Joint Legislative Committee for them to look at. They can ask us for more information if they think it's necessary, but that is something we think probably should have been done. What we're asking you to do today is essentially undo the certification of these two rules from last month and bring this back in April. There is time under the Administrative Procedure Act for us to do this. And we can bring these two rules back with the business impact analysis called for in the statute and redo it and resubmit it with that analysis attached to it in April.
I have one question. So if this business analysis, is that just gonna tell us how that will affect our bottom line here? Or if this number is appropriate with or commensurate with other?
It's not a econometric analysis per se. What the Joint Committee asks for is it's a fairly brief report that just basically lays out how much more money is this going to cost our license holders over a year, 2 years. And so and the number of people affected, the number of licensees affected. And so that's kind of the first round of what's in the statute that we need to submit to LSA. And of course, the Joint Committee could ask for more information, but that's kind of a first step in the process.
And my concern was, I just didn't want it to come back and say that instead of going up by $25 in 2 years, it should go up by $200 in 2 years. I didn't want them to come back and be able to say that that's what you should do. I didn't,
Right.
I didn't want it to push us in a further direction.
I appreciate that concern, and I think it's a step for transparency and a step for the Joint Committee to look at. And they could have questions, but I expect once they look at it, it's a pretty modest increase, and I think it'll be fine.
So they wouldn't make suggestions to do differently. Okay.
They
As far as
could.
going up,
They could.
Yeah.
Yeah, they certainly could.
but it would just be a suggestion. We wouldn't be held to going up.
Well, they can actually disapprove the rule. But if they were to disapprove, the Joint Committee were to disapprove the rule, I would imagine, receive feedback from them on what the concerns were, and we'd have to restart.
Is there any way to protect the increase? Because I mean, I've worked on a project similar before where we did an economic impact study, and it came back that we were way off, that we should have increased it far more than what we did. And so the county commission was really pushing for that higher increase, right? So how do we protect the license holders from that happening? Because I understand that these fees hadn't been increased in quite a long time.
That's right, Judge, and I think you guys talked about it and tried to make the increases as small as possible. I don't think the Joint Committee will be asking us to increase it more. I think there's a concern about just making sure that we're wise with the money that we have and we don't go higher than we need to. But I think the point is well taken.
Thank you.
Any other discussion or question from the board members? Okay, so I'll entertain a motion to withdraw certification for 680-X-2.34 and 680-X-2.35, and then request or direct the staff to do a business impact analysis and have that prepared for April for us to reconsider the certification at that time.
So moved.
Second.
Got a motion and a second. How do we vote?
Aye.
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 And I vote aye. All right, the next item on the agenda is the public hearing for 680-X.50 civil penalties and 680-X-A appendices, the schedule of penalties. Today is the public hearing for that. We have received 13 comments for this rule, and we have 3 people who have registered to speak. However, I will say before we entertain public comment, and I think we've all looked at the written comments that we received. So before we proceed with any public comment, I would ask our attorney to go over the changes that we've made from the written comments that we've received, as that may change or resolve some of the issues that we will have from public comment.
Thank you, Mr. President. Happy to do that. And are we going to bring it up on the screen? It might be helpful to have up on the screen some of the changes from the staff level that we're recommending, maybe starting first with the preliminary text matter and then moving on to the schedules themselves. I'll just, let's bring up the text part first.
Sure.
And I'll just start talking. The text matter, in my view, required some changes. I think first and foremost, and you can just kind of follow along here, wanted to make it perfectly clear that .50 is fundamentally different from .40 because civil penalties under .50 would only ever be imposed after due process under the APA. So the parts in B and C really seemed out of place. I mean, just shorten that to contested case provisions of the APA. And if you all want to impose a deadline by which that is to be paid, put it in the order. But C especially was out of place. It's not by any means a voluntary matter. This is a due process, after due process procedure. And we can scroll down. And of course, if you can see, we're striking out F, no big surprise there. After you saw what happened with .40 last time, we're not going to be imposing civil penalties for late renewals of licenses and permits. That will solely and strictly be just the late fees that are authorized in statute. So it's not either or, it's only the late fees in accordance with our sunset legislation. Okay. D and E. Let me explain what is going on here. I apologize, it's wordy. One thing that was absolutely clear to anyone paying attention to the sunset reviews and the proceedings there is they really did not like what they saw as multiplying monetary penalties for multiple legal violations. Okay. We all know, however, that there are going to be times when there are separate violations and separate fines. If I steal medicine in 2023, I'm fined. If I steal medicine again in 2025, I'm going to be fined again. It's a wholly separate matter and a separate violation. So we know that there are going to be situations where separate fines apply. By the same token, we know that there are times when you really only do one bad thing and multiple legal violations occur. You might make a clerical mistake and do 100 shipments of medicines, but it's all based on the one mistake. Well, no one thinks we should treat that as 100 violations. So somewhere in the middle, there's a balance there somewhere. There's a right approach. So what we were trying to do with, and I think some of the previous language was also trying, but I think we're trying harder to give you guys guidance as to in what circumstances would you impose separate fines, and in what circumstances would you impose only one fine? Or the way I've conceptualized it is, if you have one bad act that results in, say, 4 different legal violations, but it's really only one bad act, what we're proposing that you do is go look at the fine schedule for all of the different 4 legal violations that have occurred and impose those concurrently. Now, this is a concept that is familiar to criminal lawyers because if you go through a criminal trial or you plead guilty to 4 or 5 different counts in an indictment, you might get sentenced to prison, but you don't get sentenced to prison 4 times usually. You get sentences imposed concurrently, so you're serving them at the same time. Similar concept that we have in mind here for fines. So if you have one bad act that leads to, say, 4 legal violations, I want you to look at the different fines, but impose them in a concurrent fashion so that it's not $1,000, $2,500, $5,000, $8,500 or whatever that adds up to. But it really ends up just being the highest of those would end up controlling because all of the other fines are imposed concurrently, not separately. Okay, so that's really what is going on in D. E is just the flip side of that. It's basically the same rule with not, the word not in it. It would tell you when there are really separate legal violations, separate bad acts that result in separate violations. And when they're separate bad acts, okay, let's say you have a statement of charges come up before you where a pharmacist has done one bad thing. I mean, it's hard for me to make up examples on the fly here. Say stole medicine on one occasion and then 2 weeks later, totally separate thing, but we found it in the same investigation. You didn't label or you underfilled, in a totally different factual scenario. Those I think you could consider to be separate violations. It's a separate bad act, separate legal violation. It's not one bad act that led to 10 violations. It really is separate bad acts. Now, this is going to have to work itself out to some degree in individual cases. What we're trying to do here is give you guys guardrails and guidance on what that actually looks like and to give you legal authority to classify. Hey, these are really fines that we'll impose concurrently together, one fine. These are really separate bad acts that are separate violations. You're going to get 2 fines. I know that that's a lot of words, but does that help to clarify what we have in mind?
I think so. I think that, for somebody that's not in the legal
Right.
field, you hear concurrently and you just think like stack, 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 but it's not. It's like, if you were sentenced to 10 years for this and 5 years for this and 4 years, and you served 10 years, served them concurrently and 10 years was the worst. So,
Right.
and when you're referring to these fines, let's just say it was failure to maintain required records. I just picked one out of here.
Right.
It's $0 to $10,000. So it's not that we would fine the $10,000. If there was 4 or 5 things there, the range is 0 to 10. And they could be charged with 4 or 5 things that range from 0 to 10, but we might feel it's minor. It was a minor mistake and we could say 0, or we could say $100
Correct.
is what you're saying.
Correct.
We would just pick the, out of that, even though there might be 4 or 5 things, we would work within that dollar range of 0 to 10.
Correct. I skipped something important in D. Forgive me. Yeah, we got public comments about this, and I agree with them. The legislature gave us particular factors this is relevant to your comment, Ms. Giles. The legislature gave us specific factors to consider when setting civil penalties. And they are the level and scope of misconduct, level of risk to public health and safety, and the compliance history of the violator. That's it. Now, there could be a lot of different facts that are relevant to those factors, but those are the factors. And so where the rule as proposed had the number of patients affected, number of days operating under violation, willfulness or negligence, those are not the statutory factors. I agree with the commenters who have suggested to strike that out. You have the statutory factors, the facts that are going to be relevant to that in any particular case. Those could be relevant facts, but you're going to have an infinite array of different cases, and it's going to be different in every case. What is relevant to your statutory factors? I think we just keep it to your statutory factors here in the rule. And in individual cases, you'll have to decide what facts are relevant to those factors. One other thing, the blue text. And again, I'm looking at our sunset bill. Well, I'm looking, I don't have the right. The sunset bill is pretty chunky, but I know that there's a spot in there where our statute used to say that in setting fines, the board would consider whether the violator is a natural person or a legal entity and the annual revenues of the violator. That was in our statute to consider those factors. The legislature struck those out. And I don't want that to go just unnoticed silently. When the legislature struck those words out, that means they don't want us to consider that anymore. So I think we need to keep that in front of us. We're not going to consider whether it's a natural person or a legal entity, and we're not going to consider the size of the business and the violator's annual revenues. Those are not relevant statutory factors anymore. So sometimes when language is stricken from the statute, you can forget about it, and I want us to not forget. The legislature struck that language out. I thought that was an important point relevant to your point, Ms. Giles.
And so I think lower in that language, it says, is to protect the public by incentivizing compliance and to deter wrongdoing.
Right.
And so I think that's where, when we come into some of these, a lot of the comments, there are big numbers in some of these
A
fines.
few places.
In a few places, there are some big numbers, but they're also under the category of manufacturer, wholesaler. And when you have a manufacturer that their revenue was $50 billion last year, I don't know, I don't think $1,000 fine is going to incentivize their compliance or deter their wrongdoing. That's how I think we as a board feel when we look at that. It's not that we're saying they make $50 billion. We're just saying that I don't think $1,000 is going to even, that they're not even gonna look at that. Or a $5,000 fine, they're not gonna look at that. It's not gonna incentivize them to do the right thing.
And the point of that sentence really is to, again, it's really a counterpoint. It's not to fund the agent. It's not the primary purpose of fines to fund the agency with fines. We look at the statutory factors that we've been given, and we all have, there's fines everywhere, okay? I saw in the news this morning, we're gonna have speed cameras set up in construction zones. They're gonna do one pilot program. Well, the point of it is to incentivize people to slow down in construction zones. And they're gonna raise some funds too, but that's a side, that's not the central purpose of it. It's to get people to slow down, protect the public.
Any additional questions from the board members with regards to council's comments and changes? All right, do you want to look at the fine schedule real quick, and then we'll go to public comment?
Schedule, yes.
If I can ask one quick question before we go on that. What in the language, in this, or somewhere else prevents, say if a technician violates a provision of the act? If a technician violates provision of the act, what prevents, or is the board still able to fine the pharmacy technician, the pharmacist in charge, and the permit holder concurrently, or not cumulatively, for that same violation?
That would depend on, I'm gonna have to say, in theory, yes. but it would depend on the facts of the case and whether there really is culpability at all three levels. And it's hard for me to speak of it in the so abstractly, but I mean, if there were a case where there was real legal culpability at all three levels, technician, PIC, pharmacy, in theory, yes, all three could receive a civil penalty. It strikes me as probably a little bit unlikely that there would be culpability at all three levels, but you could imagine a case like that, I suppose.
Any other questions on, with regards to the text? Okay. You want to bring up the grid?
On the schedules, I'll just address these at a high level. Of course, everywhere, no surprise here, everywhere where there's a fine for late renewal of a license, that is being removed. There are places, and Dr. Nolan might have to help me, where the intent of it is if you're doing something, it's not talking about late renewal of a license, but doing something without first having obtained the right permit, those are gonna stay in, and I think we've tried to clarify, yeah. So there are some places where the intent was not talking about late renewal of a permit, but doing something that requires a permit without having first obtained the permit, those will stay, but the language is getting clarified. But anything to do with a late renewal of a license or permit will come out. Okay, see a few examples. So that, and this is the same as dot 40 last month.
This is under dot 1
Struck because they're not licensed by the civil matter. They haven't first obtained their license.
Right. Right. And those would be oftentimes situations where an injunction, civil injunction would be appropriate as well. Someone is practicing without having obtained a license, shipping in our state without having obtained a license. Those would be not disciplinary matters because we can't discipline someone who doesn't have a license. But it would be a matter for me to talk to the Attorney General's office about going to a circuit court, getting an injunction. The far right column, I've also recommended be removed. The Sunset Bill directed us to promulgate fine schedules for non-disciplinary administrative monetary fines and civil monetary fines. It's monetary fines. They did not say you have to have a schedule for non-monetary penalties. Now, could it be a good idea? Sure. It'd be great to have sentencing guidelines per se that you could have and you could use as guidelines in particular cases. But my concern when I looked down through that column was if that was what we were going to be limited to, we were going to be seriously tying our hands from non-monetary remedies. And so if we want to do that, let's do that later. This is only supposed to be for monetary fines and penalties. So my recommendation is to remove the non-monetary part from it. Let's do what the legislature told us to do. We can come back and work on a non-monetary set of guidelines later.
Any questions with regards to the chart and the fee schedule and the potential changes?
Again, here I go again with another question. If we see a certain, which we've all reviewed this, but it's a huge document. If we see like, where maybe, one of the fines is not commensurate with what it should be in other sections. If we wanted to lower that fine, that wouldn't be an issue. How would we go about doing that?
So operationally, what I think I would like to do
Mhm.
is we've seen the changes. The public has seen the changes. I would like to hear public comments next. If we've resolved the issues of the speakers, then speakers, please come up, let us know that we've resolved the issue. If you've got some other thing that you're concerned about, we certainly want to hear that so we can hear the public comment. And then, I think at that point in time, once we've heard the public comment, we need to come back and then address things in a certain order. And I think that order would be to accept the changes to potentially accept the changes in, the .50 verbiage, okay, the ones that, council has recommended. And then we would look at this fee schedule and accept those changes potentially. And then I think at that point in time, it would be prudent for the board to come back and then look at any additional potential edits that somebody may have suggestions that we make. Of course, after we've heard comment to the verbiage. And then we would take the fine schedule separately. So at that point in time, so I think we've got probably 4 or 5 votes that we're gonna have to take. First being the verbiage, accepting the verb changes in the verbiage, accepting the changes in the graph, in the chart, and then any changes we would want to make in addition to the changes that are already made for both of those. And then I think if we can get through all of that today, which we need to,
Mhm.
right? Even if we need to take a break and come back. Then I think at that point in time, we need to talk about not certifying it today potentially because we're making a good number of changes and I would like for it to go have some public comment before we certify it. And maybe we could shoot for a certification next month. And then also, council, I think we probably need to do an economic impact on this one as well. So that would give staff 30 days and it would give the public 30 days for some additional comments based on the changes that we make. Because I do want to take in everybody's comments, but what I don't want to do is if we can avoid scrapping and starting over, because then we start the clock again and we do have people with pending cases that need to get addressed and cleared up.
Good.
And so it's not fair. I mean, I want to be fair with the rule and I want to make sure it's right, but I also want to be fair to the people who are, sitting there waiting on an issue to get resolved.
True. But basically my question was making sure that as long as we're not making this chart more cumbersome or increasing things, as long as we're making it more fitting to the comments.
Yeah.
That we don't have to scrap it. We can just make edits and not have to start over
Yeah, but I think
for
even-
LSA purposes.
Yeah, I think even though if we can do this through the appropriate way, methodology, I would really like to try to get as many of our edits as we can, give staff 30 days to receive additional comments, get the economic impact part of it done, and then certify it potentially next month. Again, if there's some small edits next month that we need to make, some things that we get comments that we need to clean stuff up, entertain those and make those changes then. Hopefully not to the substantial level that we're talking about today. Because I think the edits that we're making today I know the edits that we're making today are made based on comments provided to us by the public. So we're trying to respond to those and make sure that we've got everything right. We're trying to make sure that we've got everything right to follow the code. Again, I don't want to delay the due process that, people are waiting to get stuff cleared up. And so I don't want to delay us another 4 or 5 months if we can avoid it by starting over. So if we can just get the proper edits done.
Would decreasing some fines in certain areas or a major overhaul of decreasing fines, would that be considered major if they're going down?
I think probably if that were put in front of a court challenging the validity of the rule, I think making the rule more oriented towards the license holder would certainly be viewed in a more favorable light, let's say. it's more favorable to the regulated community.
But if there's one single fine that we felt like was too low that we needed to increase, then that would potentially invalidate the whole thing.
I think it could be viewed in a less favorable light.
So right now, let's go ahead and hear our public comments. 'Cause I know we-
Okay, we talked about economic impact statements. We were talking about opening that up to some of these different things. When I look back at dot 2.3, that we voted on last month, should dot 23, while we're at this, should we do a business impact analysis on that?
I think we looked at that yesterday, and I think there may not have been public comments that triggered it, but I'm going to defer to Dr. Nolan on that.
Right, so the business has to notify us that it would be negatively impacted, but we did not receive any comments for .23 being impacted by a business. So
if it potentially does impact a business, but they didn't state it, then we're not in violation. By not doing it.
Right. So actually, we're at an hour and a half. So I'm going to take a 10-minute recess and we'll come back for public comment, okay? All right, so we're going to start recess at 10:34 and we'll come back at 10:45.
You're muted now, Dr.
All right, we're back from recess from everybody, and we're gonna go in, public comments. Louise Jones, representing APA, is our first person up, and Louise, you'll have 3 minutes.
Thank you, Tommy. Morning, board. Here today to provide comments on the civil penalty rule on behalf of the Alabama pharmacists, technicians, pharmacy owners, and others across the profession. I appreciate the positive steps that I've already heard being made this morning in relation to this rule, but I'd still like to deliver these comments that were written prior to hearing those. Over the past several days, we've been inundated with emails, texts, and calls from individuals representing every practice setting in every region of the state with concerns, questions, and quite frankly, a great deal of frustration and anger. The monetary penalties outlined in this proposed schedule go far beyond what anyone would consider reasonable, and they leave many of us asking, what is the board thinking? To provide some perspective, from 2006 through 2011 at the minimum, based on records we've found, fines for continuing education deficiencies past board practices as reflected in the 2014 minutes involved either making up double the number of deficient hours or paying a relatively small fine. Now, under this proposal, those same types of administrative issues would carry penalties of up to $3,000 for pharmacists and $2,000 for technicians for a CE deficiency. What makes this even more concerning is what the board refers to as a trifecta, fining the technician, the supervising pharmacist, and the pharmacy permit holder simultaneously. For many independent pharmacies, this means that the same individual may be penalized multiple times for a single issue. Additionally, monetary penalties for the corresponding statute could then double the amount charged to a registrant. Let's be clear. Many of the examples we're discussing, late renewals, CE deficiencies, are administrative errors and do not place patient safety at direct risk. Yet the proposed fines are excessive and frankly defy logic. For example, the proposal includes fines of up to $40,000 for a pharmacy, $25,000 for a pharmacist, and $12,500 for a pharmacy technician for certain violations. At what point do fines stop being corrective and start being punitive or appear even to function as a revenue generator for the board? Whatever happened to progressive discipline, warning letters, and education? Non-compliance with dispensing label requirements could bring fines of up to $10,000 for the pharmacy, $3,000 for the pharmacist, and $2,000 for a technician, potentially per occurrence. And it raises a fair question. As a side note, what role does a technician even play in determining the configuration of a label? For technicians especially, these fines are devastating. A $2,000 penalty could represent a significant portion of their annual income and may effectively force them out of the profession over a single administrative mistake. Time does not permit me to outline all of the errors in this, even if I agreed with it, or every concern we have with this rule. But in closing, the Alabama Pharmacy Association strongly urges the board to repeal this proposed rule and instead work collaboratively with those in the profession to develop a civil penalty structure that truly protects the public without imposing excessive and unreasonable financial burdens. And although the board indicates on the front of this, and I know you've discussed it this morning, that this has no economic impact, I guarantee you it will. It will close doors and it will force people out of this profession. And I don't believe that that's this board's intent or desire. I appreciate your attention and this time to speak to you this morning. If there are any questions, I do want to share with you, I've shared with John and I saw Johnny in the thing. I have, if you're interested, old from 2006, the penalty schedule. I have the one from 2011. I'm a pack rat and I keep papers. And so if you are interested in seeing any of those, the board may have those references, but I do have those if you want to compare what previous boards. I've spoken with 7 past state board presidents this week, and I can tell you all of them are just confounded by this. They don't understand what the board is doing, especially how they used to handle things. And then lastly, I have, because of the way you have to submit that schedule, my brain doesn't work that way. I'm very visual. So I have spent days taking that and making it into a spreadsheet that includes the rule name, not just the violation with the number. And then it has every person that you're looking to impose fines for in a linear fashion so that you can compare each one. So you can see independent chain, other pharmacy types, pharmacists, technicians. So you could say for failure to have late required equipment and clinical references on hand, you're going to charge dollars of different types, a pharmacist up to $1,000, and you're not going to charge a technician for that. So you could look at each one and compare instead of having to go through each section the way those were done because of the weight. I understand that's how you had to do them, but I just needed this. If this would be beneficial to board members or anybody else looking at it, I'm happy to share this with you. And I'll charge a minimal fee for it.
A lot of time went into that.
I'll use the board structure in doing that thing. How about that?
Okay, we want the zero part of the board,
Yeah.
the fine or the fee. We'll take the zero side of that.
You know, I think it would be helpful to have that so we can look at it in a different light.
I've got to finish adding a few, like 2 pages of it for the distributor, wholesaler, and other entity type. I've got to add a few pages of those, but once I get that, I can get that done tomorrow and I'll have it to y'all.
Thank you. Well, and that would give us some time to consider that between now and potentially next month to make some edits.
Also points out, it makes it easier to identify potential errors, omissions, something that's just not quite right. I pointed out to Johnny and John a while ago, there's a section on tech, in the tech, where it has immunization training. And it's got 3 different sections to it. So the first one says immunizing without a certificate, $2,000 for the tech. Immunizing not in protocol or something like that, $2,000 for the tech. And then it has, if the supervising pharmacist doesn't verify that the tech has that training, they're going to find the tech $2,000 for what the supervising pharmacist didn't do. And then under this pharmacist, it's got $3,000, $3,000, $3,000. So you're going to charge the supervising pharmacist $3,000 if they don't check it, and you're going to charge a tech if the supervising pharmacist doesn't do their job.
Well, and
Stuff like that kind of it stands out better when you have it side by side.
but I also think council tried to address, you know, those compounding fines, if you will, in his comments and what we're trying to do with the verbiage of the rule.
Absolutely.
The one comment I would make with regards to the CE, and I know this is something we've discussed before, CE is in .40. And so if you look at .40 and what the penalties for CE for not maintaining required CE is, by the time you got to this in .50, this is not your first, second, or third time you've done it. So understand, and I hope this helps people understand, right? And because I don't think it gets communicated this way. We have to have a fine schedule for every eventuality because we don't know what's going to happen in the future, and we don't want to not have a fine. Because personally, I can't imagine that we're ever going to use .50 on a CE. I just don't see that ever happening. But somebody will make this board in the future do that. Because they won't do it one time, they won't do it 2 times, they won't do it 3 times, and then now all of a sudden it's gone into disciplinary, because that should be a non-disciplinary thing, which is where it would fall. So we're having to put something out there to capture that in the future, where you have somebody that, you know, 5 times hasn't done their CE. Now, I don't know of anybody that's ever done that, and that may not have ever happened in the history of this board, but it may next year. And I don't know. And also, I want people to understand that the way those fines were done in the past were per occurrence, and we no longer have per occurrence. So when we do a range of a fine, we have to consider, and we've said this several times, and so I want to say it to you, we have to consider what would be a minor case at 0, and we have to consider what would be the most egregious thing that we would apply that fine to. And so when it says there's up to a $2,000 fine, that doesn't mean our fine is $2,000 for that. That means that's the most we would ever do and legally be able to do in the most egregious case. And I can tell you, even when we were operating under occurrence, our fines, particularly for individuals, never approached what they could have been. Because that's not the board's intent. It's never been our intent in trying to settle cases. It's never been our intent in trying to discipline someone. It's always, what is the amount? And it's been progressive. If you did it once, there was a smaller fine, and as you continue to do things, those fines potentially increased if you were somebody that was before this board multiple times. And unfortunately, in my 4 years, I've seen people here multiple times. And it's sad that we have people that can't do what they're supposed to do. So I want everybody to understand, we hear what you're saying when you say, well, this fine's really high, but that doesn't mean that we're gonna fine anybody that fine. It means from a regulation standpoint, we could, if the offense was bad enough, and assuming people get hurt, and our job is to create an incentive to do the right thing. If it's limited too much, then there's no incentive to do the right thing, and particularly when the incentive to do the wrong thing might be fairly lucrative. And so that's the balance we're stuck with. So we hear it, but we're operating under a completely different set of rules than what we operated under in the past.
I understand that to some extent, if I can respond to that for just a minute. I get that. And in some situations, I might concede. If we're talking about something using dirty or fraudulent or diluting medicine or something, cancer drugs, whatever, right? I get all that. But I think that when you're talking about a lot of the things that are in here, not just, I'm using CE as an example, but there's a lot of things in here that are similar. That you're talking about, I understand you don't have to, but even if you're saying we want that there in our arsenal just in case we ever needed it, I can't fathom a situation where the board would need to unleash a $2,000 fine on a technician for CE deficiency. If the goal of requiring CE is to ensure that professionals in pharmacy are maintaining and staying up to date on clinical knowledge and are able to protect the public health that way, right? They're staying up to date on everything going on in their profession. That's the intent, is my understanding. So if that's the intent and they're deficient some hours, what past boards have done of saying, okay, get double the amount you're deficient. If you were deficient 3 hours, go get 6. That not only is a punishment to the person, they obviously don't like doing CE, so it's a punishment. And you're ensuring that they're staying up to date. If you just hit their pocketbook, that doesn't ensure anything that's going to protect the public health. It's a correctional method and a punishment financially, but it doesn't do anything to ensure public health. Make them get more CE. And at the point that you want to go over, say, $250 for a technician, then suspend their license. If they come up here 10 times and it's an issue and it's so egregious and you're going to hit that top limit, Tommy, and I understand what you're saying, that that's not for this schedule. I get that. But I think that that's where the board needs to go. If you've got someone that's so egregious, and I understand there are those cases, there's always an exception to the norm, right? You're going to see those. But at the point you're getting those, instead of hitting them with a 6-figure penalty, or for a tech, almost the equivalent of a $2,000, you've got up to $12,500 for a technician penalty fine. It's like, when you get to that point, you're hitting over a fourth of their annual salary.
And I understand that, but I think your point is well taken, and I think is probably intended by this board when we talk about CE penalties or things like that, of doubling the CE. What we're charged with in this, because we still have all of that in our arsenal, right? We still can suspend, we can still put on probation, we can still revoke, we can still require additional things. There's nothing, to my knowledge, that says we can't do that as a corrective action, which is one of the reasons why council wanted to remove that right-hand side of the chart. What we're talking about is only the monetary penalty. So understand that, again, just picking on the CE thing, a lot of these items that we figure look like lower hanging fruit to us are also included in .40. So again, we would be well down the path of misbehavior by the time we ever got to .50 to even start having that conversation. So at that point in time, we probably have double CE and we have charged $100 and we've done corrective actions.
License.
Yeah, that's easy to say. It's a lot harder to do.
Well, you're basically gonna have them go out of the profession anyway. Most of those techs, unless their pharmacist is gonna pay it for them or their employer is gonna pay it for them, they're gonna walk away from the profession anyway. So it's not like you're doing anything to them that they would, you're, in the fine that you're proposing here, when we already have a technician shortage in this state and in this country, you're gonna chase technicians out of this profession. With $40,000 fines for pharmacies, independents or chains, today, you're gonna close their doors. You're gonna have patient access issues because you've hit them with a fine that they can't sustain.
But that's assuming we hit somebody with a maximum fine. See,
But
that's,
you got it, it's an option, and Dr. Cobb, understand this. Regardless of what this board would do, I'm not gonna make a statement on that, but you're setting a rule and a regulation that the people that sit in those seats after you leave are gonna do. I don't know what they're gonna do. So when you say, trust us, we're not gonna do that. I can tell you, I think it's an issue, and we've heard that through Sunset, and I understand y'all are trying to move in a different direction. I applaud those efforts. It definitely needs it. But what I'm telling you is, I don't trust you. And I don't mean that in a personal way or in any, I'm saying, I can't do that. And I don't know who's gonna sit in those seats when you leave. And these standards that you're setting are gonna be there until they're changed by the next people. And so what I'm telling you is, I have heard from more people on this issue than I've heard in a long time on any issue. And there is major, widespread concern over what the board is trying to do with some of these upper limits. And if you look at what previous boards have done, and that's why I have spent so much time digging through paperwork trying to find what previous boards have done, I can tell you, it is not anywhere close. It's not even the same ballpark as what other boards did. Their approach was try to work, and I haven't heard in any forum, this one, at our meetings, when y'all have had a platform every single time, twice a year at a minimum, I have not heard one board present to us in 20 years, gosh, that CE is an issue. Ooh. We got to get a handle on that. We got people that are just repeat offenders, and we got to get a handle on it. It's widespread. We got to do something major. So things that are not affecting direct patient health in here, and that's just one. There's a lot of them in here. And then to turn around and say, you know, we're going to put this in there just in case, when we haven't even heard from y'all that these things are issues. It's not been an executive secretary's report in the last 20 years since I've been here. I was here 2 years before that. So in the past 22 years, I haven't heard these type things. So when I see them in this schedule and it's these outlined over and over, and the minimum for a technician is $2,000, I believe. It may be $1,000, but it's $2,000 in here. That's crazy. So I appreciate the time. I don't mean to overstep my time limit. I appreciate, and I understand you're in a difficult position. I understand what you're trying to do. I stand behind that. I want integrity in the profession. I want people to be held accountable because I don't want anybody to put a black eye on this profession, and neither do the members of APA. But I will tell you, this isn't the way to get there.
A couple of things, Louise. I'll try to be brief, but several. First of all, those of you who are part of our discussion out front, understand Louise and I have a tremendous amount of respect for each other. We don't always agree, and we're both passionate about our positions. So there's no respect lost in disagreeing on stuff. She knows that. Just want to make sure y'all realize that too. Louise, I agree with you on the numbers. I think they're too high. I like your ideas on the CEs and stuff like that. I think you are misunderstanding the interpretation of that on the technician and the fine for the pharmacist. I think that's a pharmacist fine, not a technician. It's in the technician section. But what I think it's saying, and I have to get legal counsel, but it's saying if a pharmacist is aware that a technician is giving vaccines and they're not certified, then the pharmacist is going to be fined. The next point I want to make is the example that we talked about earlier about a pharmacy being fined and the pharmacist in charge being fined for an action that actually the pharmacist did per se. We actually have had several cases like that. I'll give you an example. We had a pharmacist who was a fill-in pharmacist who came in who was working without proper ratios, who just didn't know that these techs weren't certified. And then we had the supervising pharmacist who probably should have known that, who did the schedule, and then we had the owner. The owner was not fined because they weren't, and we didn't feel at that time was responsible, but we did feel like the pharmacist in charge who left should have been because they should have known. So there are situations where there's culpability. Is that the proper legal term?
Yes, sir.
Thank you. Learning too many legal terms. I didn't want to be a lawyer, but anyway, so I wanted to bring out that example because that happens and we have to be responsible. There's a reason why you're a PIC. And then stacking. This document stops the stacking of different cases, okay? It's just one. Now, we want to know as a board, they did this, they did this, they did this, they did this. All of those where they broke the rules, so we understand which goes to severity. So there's not going to be a fine for this, a fine for this, a fine for this if it's one case. We've discussed that, maybe ad nauseam, but I want to make sure it's understood. I hear a lot of talk about using warning letters and things like that. That is used 25 times more than penalties. Okay? You just don't see that. It's there. Letters of reprimand, warning letters, and then
Letters of concern.
letters of concern. And then was where they have to come up with
And a plan of action.
a plan of action.
Plan of correction.
That's a popular thing. The bottom line to me is what you talked about at the very end. And that is, if the pharmacy profession felt like they could trust us, that if all of these fines were $100,000, it wouldn't matter. But they don't feel like they can trust us. And that hurts, personally, because I do take that personally, okay? But I can say from the time I first started seeing what was going on with the board of, I was appointed several months before I was actually on the board and watched. I couldn't participate, but watched. You know, I've never seen those horror stories. I hear there are horror stories out there, but I haven't seen them since I've been on, and I haven't heard specifically of giving me some of those examples, numbers wise. The highest fine I've seen was I thought well-deserved, in what was done and egregious. So, I want to see us reduce the fines. It is going to, tie our hands a good bit. But that's what we're gonna have to do for, the profession until we, get our credibility back. And also it's gonna help us with sunset, or at least keep us from getting hammered again by sunset.
And I want to make a point real quick off of that. You know, we hear a lot of, you need to be using warning letters, you need to be using letters of corrective actions or letters of concern. You guys don't see that. And there's not anything in our regs that says this gets a corrective action letter, or this gets this, or this gets this. I think yesterday we sent 6 warning letters with corrective action.
Letters of concern.
We sent letters of concern, we sent, and I mean, so we had one case yesterday that we heard, one case. But then through the CRC process, we had 6 to 9 issues that were taken care of with corrective or letters of concern and warning letters and a request for corrective action. So, and every one of them, you know, could have potentially been a case where this would have come into play, but that's not, it wasn't the right thing to do. And it's not what this board's trying to do. And so, you know, for everybody that's shouting, well, you should be doing discipline without monetary penalties, we are. You just don't see it.
And I don't want to take anything away from the board, what you're doing on that. I know you're doing those. I think that's wonderful. What I'm saying is this doesn't take that into account at all from what is published in this rule. I understand it's a range, it's an up to, but again, the trust is not there between the profession and this entity of the board from previous actions. And I will tell you, based on the number of people I've heard from on this, compared to everything else over the past 20 years that I've tried to get them to comment on and get engaged on, I can tell you this has moved people that would have never written anything. People in long-term care, which was a question, just a side note, that makes me think of something. Where is long-term care in this? Are they the other facility, other pharmacy type, or are they, because they're not independent and they're not chain, are they other?
They're independent or chain,
They're under independent or chain.
depending on what type of,
Depends what type of license they
They're
have.
classified as retail,
So they
and they're independent by the AAC reimbursement, but I guess my question is, so they're classified under as independent in this?
but they could be chained.
The other would mainly be health systems? Is that institutional? Is that what we're thinking? Okay,
And
that helps.
you know, I mean, this is what I'm challenged with, what we're challenged with. I mean, and I'm gonna give you this as an example, and I'm gonna ask you a question. So there was a pharmacy out of state that the investigator went in 4 times. This doesn't involve Alabama. The investigator went in there 4 times because there were so many complaints about them compounding. And they were compounding SGLT1s out of the incorrect salt. Okay, they kept getting complaints about it. Investigator goes in, can't find it, doesn't see any evidence of this. Keeps going in because it keeps getting complaints, and finally he finds a hidden door with a whole compounding lab in the back. Okay, and these people were making millions of dollars. So when we talk about worst case scenario, that's when we're doing fines and thinking about
You can't
fines.
consider their revenue.
I'm not considering the revenue.
You just said
Okay.
they were making millions of dollars.
I'm saying that as a matter of fact. They were making millions of dollars, and they were putting into the community compounded drugs with the incorrect salt. And we know that the AG's office just took a nurse practitioner's license for that. What's the fine that's
I
fair?
think you revoke their license and they don't do business in Alabama and you put them out of business here. And that's more than any monetary fine that you're gonna put on here. But instead of imposing a 6-figure fine on them, I think you turn around and you say, you know what, you're done here. You don't do business in Alabama. We're revoking your license.
Okay, so let me tell you what happens.
Okay?
They get a license underneath their wife or their daughter or their son-in-law. And they put the business in somebody else's ownership and they sign it all up and they just keep going. And so at some point, because we've seen that. And so that's one of the reasons why from historical boards, we talk about ownership of a pharmacy is because you don't quit operating. They just change the names and move the location.
We had a pharmacist who wanted to revoke his license or pull his license because he knew he was just turning it over to somebody else to start shipping to Alabama through another person's license. And we intentionally would not accept his surrender because we wanted to know where he was because of what had been done. But we knew that's what he was going to do, is just change the name and move it to somebody else. So, I appreciate what you're saying. Yes, we need to say on those big cases like that, you're not welcome in Alabama, period.
Agreed.
And I'm gonna ask a question to that. Is there logic, and I don't know the answer to this. I'm asking, is there reason enough for the board to explore at least categories of fees and fines that are different based on out-of-state versus in-state? And I know you're turning towards me. I know I feel it. I feel the side eye. No, I know that has other implications, and I understand that you've got to stay out of legal trouble. I get that. But if the board is gonna say, out-of-state pharmacies or providers that are licensed with, registered with us, we're not able to financially afford and logistically for sending investigators out to see them personally and all that. That cost, if you say that's necessary to protect the public health from what they're bringing in, either don't license them to begin with, or say, you know what, we're gonna charge you a little bit more because it's gonna cost us more to regulate you and to make sure you're following everything. So out of state providers, which are growing by leaps and bounds on your rolls, why don't we say, not in an attempt to keep them out, but to say, if you're gonna do here, you're gonna do it by our stuff, and we've got to make sure you're following our protocols, and that's gonna cost us a little bit more to do that. And send investigators to them to watch it, and to make sure they're not having their wife sign up when they got put out and all that kind of stuff. Because if you had somebody physically going there, it'd be a lot harder to have that happen.
We use other boards of pharmacy when we can't go to do our investigations.
And if we've got a concern or a complaint, we can contact that board and have them go.
I'm taking up a lot of your time. Thank you very
No,
much.
it's a good conversation. Thank you. Thank you. All right, the next person up is Garrett Atkin from the VA. And we didn't swear Louise, did we? We were supposed to swear you, Louise. Yeah. Yeah, if you don't mind. Louise,
Louise.
we were supposed to swear you.
Oh,
Not swear at you, not swear at you, just swear you.
Do you solemnly swear or affirm that all of the statements that you presented were the truth, the whole truth, and nothing but the truth?
so help me God.
Thank you, ma'am. Will you raise your right hand, please? Do you solemnly swear or affirm that the statements you are about to give will be the truth, the whole truth, and nothing but the truth?
I do, so.
Thank you.
All right, so again, 3 minutes unless we derail you like we
It should not be taking 3 minutes, I promise. But I do appreciate the time nonetheless. It's good to be here in person. Great to see a 9-member board and great to see all of you in person. I hope to get to meet each of you at some point over the next year. My name is Garrett Akins. I've been practicing pharmacy for 15, 16 years here in Alabama, primarily through the VA, but through other businesses from time to time as well. I fully support the comments made by Ms. Jones on behalf of the membership of the Alabama Pharmacy Association. I'm not going to go into specific details regarding individual items on the pending schedule. Ms. Jones provided several good examples of those, but I do want to make some comments on the approach and design of the schedule. I'm encouraged by some of the changes that have already been presented. Mr. Devlin gave a great overview of that. I appreciate that as well. And I'm encouraged that we're on the right track here. But firstly, I think that the fine caps do seem extraordinarily high. And they could have a detrimental impact on individuals and businesses in the state for the first-time infractions or infractions that do not directly impact the safety of patients. And further, certain violations by one individual may implicate and require a significant fine of another individual. And I think there were some examples of that as we need to be, I think, mindful of that and careful of that, given the range that we have. In regards to the range, I think that the fine ranges are extraordinarily wide. This really perpetuates the perception, if not the fact, that fines are being issued discriminately and creates a vulnerability that similar cases and subsequent fines are handled inconsistently, which I think was one of the major concerns from the sunset audit. And lastly, a fine schedule that is categorized by chain versus independent versus other pharmacy practice furthers the perception of discriminatory fines and assumes that different fine amounts are necessary solely based on the type of practice setting. And I think that really needs to be looked at very closely. I believe the board should consider a more definitive progressive fine schedule. And instead of large caps in the fine range, the board should be clear as to what the threshold should be for placing a license or individual on probation or suspension. Block it, 1.5 minutes.
Thank you. All right, questions? Comments?
See, the separate schedules were mandated to us.
Based on those different practice settings?
Yes.
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 Yeah,
I'll take that up with my.
We also did not
Yeah, we
love
didn't,
that
we
idea.
we didn't like it either, but.
Yeah, it is very confusing. I know there's been some debate on independent versus chain and other things. And I think that's just an ongoing issue that we need to try to address as a state and as a profession, but may not be about the scope of this procedure.
Which I do think under this, and again, it's so hard to read when you're trying to scroll through that, it's impossible. So, we have the printed version. And on each page, I have listed at the top what it, which category it's in, but, I do believe that our independent pharmacy and our chain pharmacy fines and fees are the same. Civil penalties are the same. So it's not different. We just had to do it. They wanted us to,
I agree.
Classify
But you have
those.
to get in there and really study it to.
yeah, oh, well, yeah,
confirm
no,
it. So
no,
some of this,
exactly.
I think is, again, goes back to the trust issue and just the perception of things.
Right.
So-
And that's another thing too, is the trust issue. We now have a member board. And I know our appointment schedule is gonna be different, the way people are appointed. And so that is a concern of mine, is that as we go on, but before the governor was appointing, most of us, one of us was elected, but the governor was appointing. So it's always been sort of political, I mean, that did happen. I just feel like that with 9 people, and our new people here can attest to this, like in our discussions yesterday, how we all are looking to do the right thing, and everybody has an opinion. Like, Jeb may say, hey, I think that's too much, and when we discuss it, and we may come to the conclusion that, yes, it is too much. We all work together, and 5 of us have to agree. So I don't see that we're gonna, I just don't see that we're gonna have a board that's gonna be 5 of us trying to do the wrong thing.
And just a point of reference or just an idea, in all the cases that we heard yesterday, it was at least 8 voted the same. Tommy is always the oddball. No, I'm kidding.
It was twice.
So that shows you that the thought process is pretty much the same when the discussion happens, whether it was 5-member or 9-member. Excuse me, I interrupted you, Stacy.
No,
I'm sorry.
but that is a good point, because yesterday I think we came down to the majority of cases, it was all 9 agreed. I think there was 1 or 2 that Tommy and I might not have agreed, but it wasn't, based on a fine or a fee. It might have been on approval of a license, but, I don't understand how people can think that we can really like charge somebody $40,000. I don't believe Jeb's gonna let me. I don't think Alicia's gonna let me. If I came in there and said, I'm charging, Johnny Brooklier $40,000, I just don't feel like they're gonna say that's a good idea.
Can't get blood out of a turnip.
I mean, I'll just tell you, generally what happens is if we're getting to that level, right, then the facts of the case have gotten to the point where everybody in the room's going, yeah, this is really bad. And it deserves that level of fine because this is really bad. And I just, well, I want to step back to one comment about the schedules, being different, or being the same. We received some comments with they're not different enough between chain and independent. But we're also, trying not to discriminate one versus the other. So there's that. And then I'll also tell you, and this is something that I didn't understand before I got on this board, because I challenged my predecessor on a few things that I didn't understand. And she said, when you're here on Tuesday, you'll get it. And in 4 years, I've seen some pretty just not so big a deal things, right? And I've seen some pretty big deal things. And so when we're looking at those numbers, again, we're trying to think of worst case scenario. I'm not saying that they're perfect. I'm not, because it was a big document that we had to put together. I'm hoping that Ms. Jones will give us her spreadsheet so we can look at them from that view. But understand that in our minds, we're thinking like, what's the worst thing somebody could do right here? And trying to preserve our duty to protect the public and to provide that incentive to do the right thing.
And and one other thing, just let me go ahead and tack on to that. Sorry. I always have something to say, but, so let me just guess. Now Kmart doesn't have pharmacies anymore. Is there even a Kmart? Okay, I'm gonna use Kmart as an example. Let's pretend Kmart has 500, 1,000 pharmacies in the state of Alabama, let's say. And they're doing compounding out of state. They have a centralized compounding facility out of state. And they are shipping in, I don't know, to hundreds and hundreds of compounded prescriptions per week, maybe more. I just don't feel like when we catch them sending us adulterated products or sending us any type of a compounding issue, something that's major, we're not going to be able to say, Kmart, you can't ship in here anymore because you've got 1,000 stores in the state of Alabama. It's going to be hard to pull their license. That's going to be hard. We have to incentivize them to do the right thing. And I don't think by charging them the same $5,000 that we would charge me or Johnny Brooklier, I don't think that's going to affect them. That's where that $40,000 range comes into, is because you have so many incidences of what they sent in. And Johnny had a spider web in his compounded pharmacy. It's not the same. It's not the same. And we can't, if we're limited to $5,000, I'd hate it that if we had to charge Johnny the same thing that we charge Kmart, that's sending in thousands and thousands of prescriptions a month.
I think Dr. Giles does a really good job at explaining that, and just speaking for a new member who's only been here 2 days and probably shouldn't have an opinion at this point. Realistically, I think at the essence of the issue is what both of you spoke to, and that was trust and perception, which obviously there isn't much we could do about at this point or this stage. I mean, I don't even think that we have a right to ask for trust, right? But I do think that we have a right to ask for grace, right? Because at the reality and at the heart of the issue, we've been tasked with this task and we have to get it done. I don't think that it's people not understanding what Dr. Giles is saying. I think the issue is the trust that the board may not be able to do what Dr. Jones is saying. And I use an analogy all the time: when the only thing a man has is a hammer for something, everything looks like a nail. So there are some people, it doesn't matter what this board does. Only thing they have for this board is a hammer, and everything we do will be a nail. And they're gonna hit at it, right? But I do think that we have to work to build and gain the trust of folk like you who may very well need a little assistance in getting the trust and the confidence of the board. And I think the way we do that is informing. I may have said 3-4 times yesterday, how are we informing? How are we educating? Because I'm not seeing that. And I think, though, as the only non-pharmacist or pharmacist tech on this board, if that is my question, then I can only imagine what the pharmacists and techs are saying. And so I assure you that while it ain't easy, and if I knew now what I knew then, I probably wouldn't be here, but we are working diligently to try to earn, because we can't ask, we have to earn some of that trust, but we're gonna need a little bit of grace in doing it, because I think Dr. Giles did an excellent job at explaining that. And I don't think anybody don't understand it. I think that it's the trust and the perception that I'm not gonna get hit with $0 or $10. I'm going to get hit with 40. And I think that maybe that compromise is we move that 40 to 20. I don't know, because we have to earn that trust. But you have to know that there are people, all of us, fighting for the right thing for the profession and public safety ultimately.
I think that's good to hear. I want to go on record as I do have trust and faith in this board. I don't have any grudge or issue with this board. I do want to partner with you in terms of at least providing some insight and recommendations. I think there's some opportunities to create better transparency in the schedule. And you've talked a lot about some extraordinary cases. I think that there's some opportunity to actually further delineate out what those extraordinary cases are, so that that's very clear as to when those thresholds would be met and those fines should go up. And so right now, it seems a little open and at least appears to lack some transparency as to when you would do certain things and how you would issue out those fines. And I think there may be some ways to even get at some of the out-of-state stuff or the larger scale stuff. So not just the egregiousness of things, but I think you could also delineate out some of the scale of things as to how the fines are being issued, which would help with one single pharmacy being affected versus, maybe like a chain or a mail order pharmacy that is, that's at fault. So.
Thank you.
We appreciate you, Garrett. Thanks, Garrett.
All right, next up is Melissa Farrow.
I will forego my time. I think Louise and Garrett have both done a very good job echoing what my comments were, and I think we don't need to hear the same thing over and over again.
Okay.
Thank you, Melissa.
Thank you, Melissa. Thank you, Melissa. All right. So we're pushing almost an hour on this rule. So I'm gonna try to move us along a little bit. So the first thing that we need to consider is 680-X-2.50, the edits from council. Do we want to have any discussion on that? If there's no discussion, then I'll entertain a motion to accept the edits as presented.
That's the verbiage that we talked about earlier.
Yes, that's just the actual verbiage, not the schedule.
I think in light of the comments and in light of the requests that we have better categorization of fees and fines, like, again, what was just said about delineating the scale, I think very important that, again, the ranges are huge, 0 to 40,000. Again, the way I feel we have to proceed with this is the assumption that everybody's going to be fined $40,000 because there's the ability for that. There's the ability for that of this board, and there's the ability of that for every board. So to me, the 0 means nothing if a board has the ability to impose the maximum. I don't see where there is.
So Dr. Mitchell, we're going to get to that.
Yeah.
I will just want to take up the verbiage at this point.
But the verbiage, I think the verbiage includes adding scale or adding, I think that needs to include the,
We can edit it in a minute. I want to just so we can take it in pieces and not get too convoluted, I want to take the revisions from council first. Are we good with the revisions from council? Do we have any edits to the revision from council? If we're good as written, then we need to accept those first, and then we can make our own edits. Actually, I would like to either accept the edits or not accept the edits in total. And then we can come back and make any additional edits that this board would want to make. But I'm trying, this is really big and can get really confusing and messy. And so I'm trying to do our court reporter a favor and take it a small piece at a time. So at this time, is there any discussion on the edits from council, just on, not the schedule and the appendix, but just on .50?
again,
I think you did a good job. I like the way you did it. Pretty clear, pretty concise. Just getting it out to the public though is important, that they see it and understand it.
And I think it addresses most of the concerns in this, that for this part of it, that we received in comment. Is that a fair statement?
Yeah, I wouldn't say every single comment, but I think certainly the majority of them. And that was the goal.
And it lines us with code.
Well, aligns us with statutes and especially the Sunset Bill.
Any more discussion on just the verbiage?
again, I think some of the components, regardless of the dollar amount, I think some of the components of first offense, second offense, third offense should be included in, in the verbiage and not,
Okay, we can add that in just a minute, okay?
Okay.
Let's take this as it is first.
I make a motion that we approve, what's listed under old business OB 2.50 edits to consider.
Okay. I have a motion to accept council's edits to 680-X-2.50 as written. Do I have a second?
Second.
All right, I've got a motion and a second. How do we vote?
Aye.
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 Abstain.
No.
And I vote yes. So those edits will carry. Now I'll take up any discussion on any additional verbiage that needs to be added to the verbiage in .50.
Now, Jeb.
Now, Jeff.
Now, Jeb, it's you.
Honestly, I believe anything that I add would create it, having to reopen to, public comment again.
Well, we're gonna open it back up to public comment. We're not gonna certify today. At least that's my plan. I think since we've made these edits, we should not certify today. So if there's some additional things you want to put in there, then let's, here's your opportunity.
So, my honest opinion is, I think there's so much that needs to be changed, that we're trying to convert a car into a truck. And so I don't think edits are sufficient to do what needs to be done with this rule. I think the reason that the legislature expanded the board to 9 members was to get the full, the varied views to sort of build this from the beginning, to create a document that, number one, protects public health, but then again, builds into this verbiage the level and scope of misconduct, the level of risk to public health, and the compliance history of the violator. I think all we've done in this verbiage is say that's what we're gonna do, but we've done absolutely nothing, period, to give any written guidance to this board or any future board, that can be consistently followed. So I think we're doing a great disservice to the public. I think we're doing a great disservice to the professionals that are licensed by this board to try to convert, again, what I call a car into a truck. So there are no amount of edits that I can sufficiently add sitting here to make this into what I believe is what the legislature intended, and what our professionals licensed by this board want, need, and deserve, especially in light of trust and transparency that has been missing from this board for a very extended period of time.
All right, any additional comments?
Jeb, I just ask you to please, document those, write them, whatever, and, share them with,
Anne Marie, and then Anne Marie can just disperse them to us for review.
and totally rewrite it. Let's look at it. We're always open to something better. I think this is, obviously I wouldn't put voted for if I didn't like it, but if you got something better, I'd be more than willing to look at it and consider it.
And so I understand this to just be verbiage, just to ensure that we are in accordance with both the Sunlight Report as well as the legislative law. Is that incorrect, Mr. Attorney?
You're talking about the edits to
Yes.
the text at the beginning?
Correct.
That's the
We
central
are missing
intent.
the bone, right?
It's
So I
sort of the-
do think there's, space and room for us to make this car a truck, Jed. This is just the bare bone, beginning of what's legally required without any conflicts to the report and the law. As I understand it.
And I think that's also, and maybe not to Jeff's point, giving the new members, especially the 2 new members, a chance, since you don't have as much historical reference, and not an opportunity to turn the car into a truck.
All right, need more discussion on it? Okay. So we've got approved new verbiage for 680-X.50. We need to look at the fee schedule. And again, we can make some edits to the fee schedule if y'all want to make edits to the fee schedule, but I would like to take up the attorney's edits first. So what we've got in those edits that we've already looked at is striking of the corrective actions that are non-monetary on the right-hand column. striking failure to renew in each location.
Hold on, can you bring that up? Just so that people can see what we're talking about. It's really just where they strike out probation, because we're not allowed to use that in a monetary penalty form. Just so they know that what we're voting on, it's just,
Right.
yeah, it's just the red where they strike out.
So, and we struck out operating without an active permit. In 680X 3-01, page 6, you'll see it's changed to practicing without having first obtained a valid registration, which would also be a referral to circuit court. I think those are the major changes. So the first item I want to discuss and seek approval for is to edit the schedule per the attorney's recommendations. Is there any discussion on that? I think counsel laid out a very valid and sound argument for his changes. No discussion? All right, I'll entertain a motion to approve or to accept the changes and approve with edit. 680-X -A.
So moved.
All right, I've got a motion. Do I have a second?
Second.
Got a motion and a second. How do we vote?
Aye.
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 No.
And I vote yes. So those changes are accepted. Now, we'll talk about any changes to the monetary fines. And yes,
I was just gonna let you finish and then say something, sorry.
okay. So any changes to the fee schedule that we want to make, now we'll start having those discussions. Yes, ma'am.
Yeah, so I did agree with Louise as far as technicians go.
Okay.
Technicians, to me, the penalties do need to be reduced. In my opinion, I would say technicians at a maximum, and it's just, I've been doing this for 20 some odd years. And I go into this knowing that if I do something wrong, I'm gonna be penalized. I know this. But at least to me, as far as a technician goes, it should be a maximum of, and just, because it's gonna hit hard, a maximum of $750 or $1,200. Like, because that is a lot of money to a technician.
Yeah. And so I was thinking the same thing. What if we made 1,000? That's in between your two numbers. Or we only got 750 maximum for a technician. Any discussion on the number?
Louise shaking her head. Louise? What number are we seeing out there? Because now we just had Alicia tell from her technician point.
I think it varies depending on the violation.
Well, and I agree.
And I think, I think a max of, 500, 250 to 500 at the most. I mean, I just think that if it goes beyond that, I think you've got a technician that doesn't need to be practicing right then until they receive either other training or something and you suspend. But when you go much higher than that, you're chasing them out of the profession.
And I could agree with some of that, but I'm looking at, if you have a technician that's that far, I hope before then, we've already spoke to the technician and they've fixed their errors. Because I know that the first thing I do every year is I go, it's time to renew. Or when I walk into my pharmacy, I'm going, okay, am I doing the right thing? I even go as far as, is my count correct? But that's just because I've been doing it for so long. I try to walk the line and do the right thing every single day when I walk in. And I mean, I just got to my figure because if they've reached the point of this and 750 within, it wouldn't hurt, it would hurt. Don't get me wrong, it would hurt, but it would be a little easier.
I think that you're at Where we would like to see you come from is more of an approach of education, training, putting them in something that's, it's a punishment, but it doesn't hit their pocketbook, but it requires them to undergo some sort of training, whatever that might be. And so that what you're doing is not just penalizing them for, with a fine and hurting their bank account, but it's something that is creating in them either more education, raising awareness level where it's not the punishment necessarily this part, it's how do we work with this person to bring them into compliance where they don't continue to do this?
So
Yes.
already done that.
And so it's-
Why can't you have your time, please?
hang on. Judge, you were gonna say something, I'll
Wouldn't we
recognize you.
have already done that in .40?
You could have. and
Before
at the
it-
point
before
they
it's gotten
continue to
to
be
Hang on.
deliberate and ignore you, you don't let them practice in this profession.
And that's certain,
Just say, we're gonna use the hammer, to use your example, of a $40,000 fine or 12,500 or whatever it is for a tech.
Louise, I think where we're getting lost in this is that we're just talking about monetary fines. We're not talking about all the other things that we're trying to do to get to that point. The monetary fine may be,
Monetary fine if you do those other things.
what?
I'm saying you don't need the monetary fine if you establish all these.
Hopefully not, but I still have to have them there.
I just.
Still have to have them there.
I just disagree to the extent that you've got them in this schedule. I disagree.
Well, if they're not in this
This
schedule,
board has started to use monetary fines as their hammer.
Who?
And this board, the board, previous boards recent to this one and this one, you're viewing it and you're utilizing monetary fines as your main hammer. And I don't think it needs to be your main hammer.
and I would agree with you,
That's what I'm
Put
saying.
it on paper.
but
Put it on paper.
But you say you agree, and I appreciate that, and I'll take you at your word. But I'm saying that what you're proposing this does not show that. What you're proposing in this is something completely different.
okay, we've heard your comments, we appreciate them, but we've got to move along. So in the technician schedule, you're proposing, Ms. Booker, to have a different number. What would that number be?
Well, I mean, I was gonna go with, I said, 750, but I mean, I could even agree with Louise that it is a technician and it is hard. So I would say, let's, we start with maximum of 5.
Okay. So just a discussion about maximum of 500 across the board.
My comment is, I like that, but I think we should take a few specific ones and take them out.
Okay.
For example, CE.
And I agree with that.
Hang on just a second.
Start at the beginning, instead of jumping around, can we just start at the top of the
Well,
list?
what she proposed was 500 for all of them.
Yeah, I think there's some that need to come out too.
Well, and that's what he just said.
Yeah, if we could go in order, instead of jumping around.
Okay, start with keys and access to the device under control. I think
How does that relate to a technician? When would a technician be fined under that?
the max as being proposed is 500. And, you still can do letter of reprimand, or letter of concern, or any of that too.
Is this a way to layer charges? Because is this a way to layer charges where we're finding the technician and the pharmacist and the supervising pharmacist?
Council's already addressed that.
Yeah.
That's been asked and answered
So
numerous times.
yes, we can, right?
We can, but the intent is not to do that unless there's culpability on both or multiple parties.
If the pharmacist in charge gives the keys to someone who's not supposed to have it, and they're a tech and they use it, then both should be fined, in my opinion, or at least given, if not fined monetarily, should be reprimanded to some extent, because they both committed wrongdoing. You just can't send a letter of reprimand to the technician and not go after the pharmacist in charge that actually gave her the keys, or at least my one vote would be that the pharmacist that gave her the keys should be responsible too.
But there's, again, if we're trying to encourage people to come into this profession, the longer this fee schedule is, if I'm a technician and I say I can be potentially fined with 47 different things that I'm counting on my supervising pharmacist who's responsible for controlling this stuff, when I see a potential fine schedule that's 4 pages long, I don't want to be a pharmacy technician if I can be subject to penalties for all kind of things that I'm not even empowered to control. And we'll get into that more into some of these later ones. But again, the perception of this board is that we have these fine schedules set up as merely a way to bring in money. And so by having every single one of these things that we potentially can find a technician for that doesn't even relate to a technician duty, we're telling the legislature that we still want to just derive money out of fines and penalties. And again, whether we do it or not, the perception is we can. And as a leader of pharmacy, not just what the 9 of us are going to do. So I think these tables should be much, much shorter, specific to specific things that we would want to be able to affect the actions of a technician with, not everything that goes on in a pharmacy that gives us the ability to find everybody we possibly can. You know, and again, like she said on number 2, non-compliance with dispensing label requirements. Even if that's $250 for a tech, the technician is, the requirement of being a technician in Alabama is not that they know all of the required elements of a prescription label. And so why should I be able to find a technician
All right,
for that?
I've got to move us forward.
Yeah.
Or we're going to be here all day.
Well, and
Hang on,
keep
hang on,
going down.
hang on. Secretary Lena, you had a comment.
I was gonna ask, when Ms. Booker recommended a maximum of 500, if the recommendation was to proportionally reduce all technician fees, because they're not all the same maximum. So would the logic be if, say, $2,000 or $3,000 was the previous max, is every one of them reduced by 75%?
So, Ms. Booker, what's your thought on that? Okay, so we're gonna have to take this a little bit at a time, or we're not gonna get anywhere. So I want to take the first edit that I need to seek approval for is to reduce the technician fines. And Ms. Booker, would you state exactly, because you're gonna, I'm assuming, making a motion on this. Would you state what you want the fines to be?
I would say, based off of my years, number one, I would never want to, this would never be my first move on a technician because, you know, we always want to educate, retrain, whatever, instead of taking money out of their pocket. That would never be my first choice, and this isn't a first choice, I know this. But I would say, with technicians, maximum of 500, yes.
Okay, but maximum of 500 across the board, or do you want it allocated at the current maximum of 7,500?
How would it sit with you if we just said a 90% reduction across the board? That'd take a 2,000 to a 200, but the higher ones would be. How does that sit with you guys?
I'm good with that.
I think that's fair.
Any discussion on that? So what I
And then
hear,
we can further discuss the ones we want to strike completely.
right, that's what I want to do next.
I know.
We're talking about
I just
technicians
wanted
first.
to confirm.
Yes,
All right, so,
good idea.
so the motion or what I'm asking for a motion for is to take the technician fee schedule, fine schedule as a whole and reduce it by 90%. Is that correct? So
Oh, yes,
you
sorry.
have a motion.
Motion.
Second.
All right, so I have a motion and a second to reduce the technician fee schedule by 90%. How do we vote?
Yes.
Aye.
Yes.
Aye.
The same.
And I vote yes. So, Mr. Secretary, in the updated version, if you would reduce all of these by 90%. All right, now the next item I want to take up is a discussion on which items to strike out of the technician schedule. The first one I heard was non-compliance with dispensing label requirements.
0.13, yes.
Okay, so we're strike 1.3, and I'm gonna get them all together and then we'll vote on them and discuss and vote on them as a packet, please. All right,
Is there any way, Mr. President, that we can identify all of them? Maybe you all have that data already that does not deal directly with patient care, and then we take that up as a group?
I don't know that we have those identified.
Dot 2.1, failure to maintain required records. I don't know that that's the tech's, responsibility, but the pharmacist.
I think we skipped some. Do we just not need to go down the list?
Yeah, let's go down the list.
Didn't see any.
Okay, so you didn't see anything before that. So does anybody see anything? Well, I'll do it this way. Is there anything in .18 that you want to strike?
I guess back to dot 4, are the technicians responsible for knowing who's certified between the other technicians?
Ratio, I think, would be the,
Which one is he on?
Because there's 3 different parameters based on who's certified and not certified. Is my technician supposed to know who's certified and not certified in their pharmacy? To know if they're exceeding a ratio?
I mean, it's the scheduling individual's job and the PIC.
It's the PIC's job, but is
Yeah.
that an individual technician's job? And all 4 technicians are gonna be fine because they're over?
Technician, to me, that's not their responsibility.
Yeah, if you're scheduled to work as a technician, you're gonna work as a technician. I
Yeah.
don't. I
You
think
don't
we-
check to see.
Okay,
I think we're striking.
so I hear enough to strike that. All right, I'm gonna move to 1A.
Is that the job of the technician or pharmacist in charge?
To follow required policies
That's a
and
text.
procedures.
Maintain and follow?
Well, maybe not maintain, but to follow.
I think following required policies and procedures is the number 1 duty. Probably,
You just strike the word maintain.
All right, is everybody okay to strike maintain?
yes.
So failure to properly manage drug storage and distribution. Is that a PIC job or is that a technician job?
It could be a technician job in different settings.
But is the PIC ultimately responsible for that?
It would be 2.
They would be too.
So you're still on 1.8? 1.8?
I'm on 1A.
Gotcha.
So we're also looking at technicians in other settings because like in a hospital, they do different things. I'm not at my store. We know what they're doing, but it may be in a hospital. Somebody's in charge of storage. Is that correct? Is a technician in charge of storage?
Could be.
This is if we're wanting to layer and find as many people as we can, because again, I think the pharmacist should think that the pharmacist in charge is responsible for the overall supervision of this.
At the hospital that I worked in, we had an IV pharmacist that was responsible to make sure all that was happening during different shifts.
We designate a PIC in Alabama for a reason. We don't promulgate those duties to a technician by code, correct?
So I think we can sit here and argue this all day. I think at this time, what I'm gonna do is ask the board to instruct our secretary to take comments from the board members between now and in 2 weeks. So that anything any individual board member wants struck, they can go through that list and put what they want struck in the comments. And if they want to have a fine reduced, put that in the comments and then have that for us to consider at next meeting. Because otherwise, I think we're gonna be here for hours on this one thing. And I'm just trying to use our time efficiently because we still have other stuff on the docket to get through. Is that acceptable to the board members? And that gives us some time to listen to comments, to get Louise's chart, which I hope she's gonna share. And then strike the things that we feel like we need struck so that we can use our time efficiently. Is that acceptable to this board?
Does that need to be done in?
Yeah, I'll have to.
I think people could ask questions about the transparency of the process. So what I would suggest is it's permissible for board members to communicate views to the executive secretary because he's staff. He's not a board member. But I think what has to happen is that the executive secretary will collect all of that, and on day 15, we're going to allow 2 weeks. Brenda, do something to make that public on the board's website or something so that everybody can see, here's what the views are. And then we could come back and,
That's exactly why I want to do it in a shorter timeframe. While it's fresh in everybody's head, they can read through it and go, this doesn't make sense to me, this doesn't make sense to me. And, you know, as far as I'm concerned, if there's enough, you know, he'll get the feedback, and if there's enough strike comments out there, then he can put a red line through it and say, you know, majority says strike or majority says change or whatever. And then that way we can put it back out in 2 weeks for people, everybody to look at. And then we can come back and revisit this in hopefully a more efficient manner where we can take things up in a bucket as opposed to one by one. It just seems like that's gonna be the most efficient way, and I know it's gonna probably delay us. Because we may not be able to certify in April, we may certify in May, but I want to get it right. And I want everybody on this board to feel comfortable about it. Or at least as comfortable as we can get you. So I'll entertain a motion.
I'll make a motion that the staff put together, and take comments from the board as to what should be stricken and changes net made in monetary fines. And in 15 days, post that on the website for public comment.
So I got a motion.
Unreadiness.
Do it.
Unreadiness, are we speaking specifically just to 0.08 with pharmacy technicians or the schedule in its entirety?
Schedule in its entirety. I'd
Would
like
it be permissible then, before we do that vote, to maybe take 5 or 10 minutes to have a conversation among board members with primary concerns in each section so that we know open on record what everyone's ideas are before we have those conversations via email?
I have no problem with that. Is it acceptable, everybody?
Yeah.
All right, so
Did that?
we're gonna time this. We gotta be quick, okay? So I'm gonna go with civil penalties. What are your major concerns in civil penalties for chain pharmacies?
I have a bunch. To me, they're too high, need to be dropped, and I'll put that in my comments to the staff.
Across the board, you're the too high.
Yes.
Okay.
And independent the same way, well, to change.
All right, is there any other major concerns in chain pharmacy that we need to address? All right, I'm gonna move on. Independent pharmacy.
Need to change, you gotta do it for independent, so they're gotta be the same. And to make it a little bit, other pharmacies is gonna be the same way. I'll still have to be.
So what, are you saying a specific, they need to be dropped, but are you saying a specific amount or?
I have specifics on each one. I didn't say a percentage, which would be nice, half or something like that, but I didn't do that. And I didn't do the other categories because I was afraid I'd come up with a different number and I wanted to match. So I've got Louise's spreadsheet. I can see it a lot easier. But my numbers are close to half, and some even more.
Okay. Civil penalty schedule for all other pharmacy types. Anything that specifically needs to be struck or general comments of issues? Okay, not hearing any civil penalty schedule for manufacturers.
Any comments on the numbers on the manufacturers?
Civil penalties for distributors. Civil penalty schedule for all other facility types.
I think those would be comparable to independent chain.
Okay, so monetary issues.
Yes.
Civil penalty schedule for pharmacists. civil penalty schedule for pharmacy technicians.
Okay. Yes.
Yeah, I have some on that, on those two.
And which,
Decrease. The CEs and some of the fees.
okay. So fee schedule. Agreed.
And to, in the spirit of transparent equity, never mind, we'll get to that via email. So I certainly on CEs.
Civil penalty schedule for pharmacy technicians.
It's already in the works.
Okay. Well, I think my intent is to work the whole schedule. So if everybody would, if there's a monetary change, or if there's something that needs to be struck, then we'll do that. Now, we have a motion and I think we had a motion on the floor. I don't know that I got a second. I've got a motion and a second. So, how do we vote?
Aye.
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 And I vote yes.
And just to be redundant, and I'm sorry that on the time, but we're gonna post that on the website in about 15 days. And then y'all call us.
All right. Update on the rules and rulemaking process. There are 7 rules in the rulemaking process. Proposals can be found on our website under statutes and rules. The following rules have their public hearing April 15th. Comments are due to Wendy Passmore at wpassmore at albop.com by end of business on March 13th. 680-X-1.01 organization, 680-X-1.02 Office of General Counsel, 680-X-2.23 drug manufacturers, wholesale distributors, private label distributors, repackagers, third-party logistics providers, outsourcing facilities, reverse distributors, retail medical oxygen suppliers. 680-X-2.36 continuing education for pharmacists, and 680-X-2.37 continuing education for technicians. The following 2 rules will have their public hearing May 20th. Comments are due to Wendy Passmore at wpassmore at albop.com by end of business on May 15th. 680-X-2.05 community pharmacies, 680-X-3.03 time and method of payment renewal and non-disciplinary penalty for late renewal of controlled substance permits. I don't have any agenda items for board travel. I think we've already approved everything that's in the near future.
I have one issue. I will not be able to attend NABP on, May the 12th through the 15th. So that leaves one slot open if someone else wants to attend.
Same. I will no longer be able to attend NABP.
Okay. Well, we approved what, three slides and I'm the delegate, so that's the 4th.
Okay.
So if any board members want to attend, please reach out to, look at your schedules and reach out to, Secretary Lena. And,
Do we need to approve that today, though?
well, we've already approved 3 spots.
3 spots,
Yeah.
okay, okay.
I can't go. I'll be in
Yeah, you got
Washington anyway, so.
We should determine who's attending the student interviews at Sanford and Auburn.
Well, Sanford is at the end of a board day, right? So I think it is.
Yes.
Anybody that were already here. So any and everybody that wants to drive over to Sanford campus. What day was Auburn?
24.
24th, I think.
It is. Just double checking.
I want to go, but I won't be on, board's dime. I go visit my son anyway, so.
I'm in town, so
I'm in
I'll be
town.
there.
Yeah, I'm close. I can go. So that'll be 3 of us, 4 of us. Anybody else want to attend?
I'll be present.
Either way.
Okay. So you'll have enough people for Auburn?
Yeah.
What was the date of Sanford? I know I've got it on my calendar, but I can't find it.
I think it's the 14th.
Tuesday of our board meeting.
Yeah, April the
Yeah.
14th, Tuesday of our board meeting. We're here.
Make sure we're not overbooked, please, that afternoon. We need to make sure we're not overbooked that afternoon.
Because it says it starts at 4, so we'll need to,
It's the 14th, April 14th.
at
I
4.
did not have it.
All right, the next item on the docket was review numbers of outstanding cases. That's in your Dropbox. Counselor Netling, were you going to review that or?
That is a new piece of information to me. I didn't, I'm happy to bring a report to y'all next month. But I'm afraid I don't have a report for you on that right now.
I think this is, oh, I know what this is. This is the, no, it's not.
Number of pending cases.
Yeah, it's the number of pending cases. We have 28 with SOC issues and 161 total cases. Quite a few of them look like they're going to follow the .40 pathway. And I know we talked about this last month, but you guys were going to look at how many of those we could, and what process we could dispense of those with 0 fine. Have y'all had a chance to look at that?
We have not.
Okay. I mean, again, when we voted on this last month, I believe, but I would like the information for the board to have of which ones and how long they've been waiting. Because a lot of these folks have been sitting around for quite some time with having to fill out applications, et cetera, with pending board issues over clerical problems. And so I think they've probably suffered enough. So I'd like for us to dispense with those as much as we can at a minimal.
I think from this report, many of these entities are not aware that they've had an issue, because some of them are, fair number are, supervising pharmacist, designated representative changes, change of address, stuff like that that comes up on applications, and we approve the application, but it opens a case because there's a mismatch.
There are quite a few that are pending from a year ago.
There's still the other stuff. There's still the
Yeah.
other stuff.
And so we need to look at the ones that have had those issues. Let's try to clear those up quickly and as minimally cost as we can. All right. The next item is under new business, so we'll move on to that. Yeah, from a new business folder.
I don't have any business.
Wendy, can you put our new business folder? Do it.
In the old business folder.
Oh, so it got dropped in?
It's in the old, okay. Thank y'all.
That just happened. Thank you. All right, so the first item is joint resolution for collaborative pharmacy practice. The joint rules on pharmacy collaborative practice require the joint committee to meet at least quarterly. Staff at BME and ALBOP have conferred and determined that there is no matter pending for consideration by the joint committee. Accordingly, there is no need for a joint committee on pharmacy collaborative practice to meet during Q1 of 2026. There is a combined joint resolution for everyone to review. You'll take a second and review that. If there's any discussion, I'll hear it now. If not, I'd entertain a motion to approve the joint resolution on the joint committee of pharmacy collaborative practice.
So moved.
Second.
All right, I got a motion and a second. How do we vote?
Aye.
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 And I vote yes. The next item on the agenda is review of potential rules to add to chapter 680. And
This is not new information to your council. In the old business folder, if you click into new business, 11 there, you will see 3 new proposed rules for you guys to look at. Let me tell you where this comes from. In the sunset bill, one thing the legislature ordered us to do was to review all of our rules, every single one, and identify situations where our rules were in conflict with our enabling legislation. Your executive secretary and I did that, but we also went a little bit further and identified gaps where we should have rules under state law but don't. And so there's a handful of things that we need to adopt rules on. And so I've just brought you 3 today, and I'm not asking you to vote on them. Let me just kind of explain real quickly what they are. And I don't know that these numbers will stay the same, but 680X102 is a rule on petitions for rulemaking. The Administrative Procedure Act requires us to have a rule. It is mandatory where members of the public can petition the board to engage in rulemaking. And there's a process that we have to follow. That rule is absent. We need to have it. 680X1.04 is a rule that would govern the use of electronic signatures. I know that we already use electronic signatures. State law says that every state agency is to determine by rule whether and to what extent to use electronic signatures. So this is a first draft. This is actually based on a model rule that the State Department of OIT has. It's adapted more to our context. We are at the staff level looking also at whether the electronic signature, digital signature deployments that we currently have comply with OIT guidelines. That is something that's in flight right now. That's why we're not asking you to vote today. We want to make sure we don't write a rule that we're immediately in violation of. So let's take a look at that. And then third, again, going back to the Administrative Procedure Act, 680X1.03, the Administrative Procedure Act requires us to have a rule by which members of our regulated public can ask us for a declaratory ruling on how our rules apply to their specific situation. So if there's unclarity about how our rule applies to what they do, they can come to us and ask for a ruling about that. And then that rule is binding. And if they don't like the ruling that we give, they can actually get judicial review in court. But we're required to have that, we don't. So my ask of you guys is take these 3, look at them over the next month. And I'd love, if it's the pleasure of the board, for us to start the rulemaking process on these next month. And I believe these should also be in the website. So any member of the public who sees these, who would love to comment on them, feel free to email, any one of us on the staff. And we're happy to consider that before we even start the rulemaking process.
So my question was going to be with 2 and 3, not 4, because you said 4 was still under revision, right? With the state guidelines for
Well,
electronic signature.
they're all
Still in flux.
They're all these are just drafts for y'all to consider before we even start rulemaking.
Okay. Any questions or comments for council? All right, the next item of business is the October meeting dates. So I was looking at some of our documents as I was trying to plan something. And we've got some documents that have our date, October 19th, our 20th and 21st. And we have some documents that have our dates the week prior. On the website, it's listed as the week prior. I have a conflict the week prior. And I know that hotels and some other things are already set up for that former week. Or the following week. So is everybody available? I know we've checked with council already. I believe you're good the week of the 20th and 21st. Is everybody good to make that our official week? Because we've got a conflict we need to solve.
I have that as my official week. I already have it.
I did too. Everybody good? All right, so I'll entertain a motion to set our meeting dates for October 20th and 21st.
So moved.
Second.
All right, how do we vote?
Aye.
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 All right, thank you. All right, that is the last item I have on our agenda. Is there any more business to come before the board today?
I'd just like to make sure everybody realizes we do read your comments and want your comments. Please feed us those. I made several calls of the people who commented last time and had some great conversations, and I may do some more after those who made comments on these. Because they need to, not everybody's able to listen to the whole hearing.
Anything else? Any other matters today?
For the spreadsheet that y'all would like a copy of, do you want me to go ahead and change the technician to the 90%?
Please.
Before I send it?
Sure.
Okay. Make sure that's-
All right, thank you. That's gonna help us in the view.
How are we gonna print that though?
You need tabloid paper,
What?
tabloid size paper.
You're gonna look at it on your
Bigger than
computer.
legal.
Or some scotch tape.
I was gonna say,
Some scissors.
my method is Scotch tape, so there you
I'll pay you to mail it to me.
go.
All right, if there's no other business come before the board today, we are adjourned.